There is delay.
Delay.
Next.
Item number 2.
Who is the Mr. should have Mr. Not present. Copy on the stage. This to my 8th November.
Item number 3.
In absence of GST,
Illegal?
no, it is under. 4 and 5, sir.
4, 5, 5. 4, 5.
Item number 6.
6, my lord, there is delay, I will pay 100%, I am giving similar. 6 and 7.
6, 7, 100.
6 and 7.
Next.
Item number 8.
My brave lordship may take up next item, item 9, because 8, my office record is not properly paginate. May take up next matter. Same matter, issue same.
Item 9.
9, next.
What is the issue?
Here, my lord, what has happened? The petitioner could not participate in the proceeding before the appellate authority. So he stood ex parte. The demand notice was received by the petitioner accompanying with the order of the appellate authority. Then he filed an application before the appellate authority that he may be heard again, the rehearing to be taken place. When this application was pending before the appellate authority, he came to this honorable court in a writ petition that is 11706 of 2023. That order I have quoted in the page number 3. That this honorable court, taking into contention of my ex parte and taking into hearing the department, will directed the OP number 2, the appellate authority, to consider the dispose of the representative as per law. Then what he did, Miller, this order, Miller, certified copy of the order, I have submitted to the department with a prayer that I may be participated in the proceeding. That you will also find at page 57. You will also kindly turn to annexure 8. This is annexure 7 was impugned in that writ petition where the honorable court directed to dispose of. This was the representation I have made. Then you also kindly turn to next page, next annexure page 63. This annexure 9, paragraph 2, page 63.
What are there to dispose of?
No, Miller, what he did, Miller? Miller, the impugned
What
order.
the court will, for everything the court will pass order?
No.
Is it Dhakamara machine?
No, court has.
Our constant Dhakamara machine. Machine
But court has directed to.
Sir, that's what I'm saying. What is there that could not be solved? That's a court has to direct.
Miller, this admittedly, Miller, I stood expert because I could not that uploaded the notice. I could not. It was not within my knowledge, so I stood expecting. Admitting all these facts before the court said the dispose of the representation. They have disposed of this representation, saying it is not coming under section 161 of the GST Act. Okay. So my humble submission before your lordship, Miller, In Annexure 9, when I have enclosed the certified copy with a prayer to allow me to participate in the proceeding, my lord, they pass the impugned order at Annexure 1, page 15. My lord, this order they have unilaterally passed, my lord, after receiving my application. Your lordship, my lord, reference, your petition dated 6/2/23 received in this office on 14/2/2023, that is Annexure 7. They have received. And dated 9/5/23, which I have filed a application accompanying the order of the court, this honorable court. They have passed the order on 17/6/2023. They have quoted the provision of 161, paragraph last page of that page 15, last para, without prejudice to the provisions of section 160. And notwithstanding anything contained in any of the provisions of this act, any authority who has passed or issued any decision or order or notice or certificate or any other document may rectify any error which is apparent on the face of record. Since it is not apparent on the face of record, my lord, they have rejected my application. My only submission before lordship.
Then what is the problem?
The problem is that,
Rightly
my lord, if you also see, my lord,
If you are saying it is not apparent on the
sir,
face
you
of
also
record.
kindly see 160, section 160.
161.
161, before that 160. But 160, subsection 1.
Yes.
No assessment, reassessment, adjudication, review, revision, appeal, rectification, notice, summons, or other proceeding done. Accepted, made, issued, initiated, or purported to have been done, accepted, made, issued, initiated in pursuance of any of the provisions of this act shall be invalid or deemed to be invalid merely by reason of any mistake, defect, or omission therein. If such assessment, reassessment, adjudication, review, revision, appeal, rectification, notice, summons, or other proceedings are in substance and effect in conformity with or in accordance to the inputs, purpose, and requirement of this act or any existing law, my lord. Now, my humble submission, you will also kindly see 107. It says, my lord, if it is not in conformity with law, 107 subsection 12. 107 is the procedure of appeal. Subsection 12. The order of the appellate authority disposing of the appeal shall be in writing and shall state the points for determination, the decision thereon, and the reasons of such decision. So he has to distinguish, my lord, what the adjudicating authority has passed. Here, the appellate authority, my lord, while passing the original order, has not discussed. He only copy paste the finding of the adjudicating authority. He has, as per the law, my lord, 107 subsection 12 says it has to be discussed and distinguished, my lord. That we did not see. So my humble submission before my lord is that they had passed the order, right, my lord, but I should have given an opportunity of hearing, my lord. I only before your lordship for violation of natural justice. I only before
You have
lordship.
not been given an opportunity.
I have not given up this time also.
Expert order.
Ex parte order. First ex parte order, then came, then again the order passed it ex parte. When I have specifically
Who has approached the authority?
petitioner, my lord.
So how can it be expert?
No, we have approached with
Sir,
the
you have
representation
approached to the authority.
authority. He has not passed. He has not allowed me to participate in the proceeding.
How?
You know, kindly see. Annexure 9, page 63. Page 64 is the prayer. This is on 9.
You have approached, you have brought every facts, everything before the court.
Court will have passed this order without taking into account.
Sorry, that court, the officer.
Appellate
the
authority.
officer. Appellate authority.
But if you also see annexure
So,
impugned
how
order,
can you say that no, there is no the natural justice is violated there?
no, unilaterally he has passed the order behind my back.
Doesn't matter.
Even
He can pass.
he can pass.
Yes.
While passing such
On merit, he can always pass.
no, your lordship.
It's not necessary that he should be present
But-
there.
Yes, yes.
In many orders, they are passing.
That is the
without it.
principle of natural
Even if-
justice, my lord.
Not
If your lordship-
necessary, not necessary. Sir.
My lord, if your
Since
lordship
you
allow,
are the petitioner,
my lord,
and
if
you
your
are in
lordship,
the
if
petition,
your
you
lordship
should have
allow
decided.
me, if your lordship allow me, I can cite 2 judgments of different high court.
in our high court, I have also passed an order with Justice C.R. Das. See this same issue.
I have not
Yes.
gone through, but the
On
judgment
the,
of
on the issue of that.
judgment of
Even if that, I mean, if, so the judgment was, you cannot dismiss ex parte. So, however, you can pass out on merit.
Yes,
That
he has
was
not
that
passed
message.
it. He has not passed it on merit. He has to, under section 107, subsection 12 says, my lord,
Mm.
it has to be adjudicated.
So let's go to the appellate order.
Order. Annex of 6.
Page.
Page starts from page 48.
Page 51.
Page 51. Yes, I am also there. Page
Could you
51.
say it's not discussed?
I'm
That's,
just,
you didn't discuss, didn't it?
I'm reading it. Gone through the summary of order passed in form GST DRC 07 issued by the LPO, as well as the grounds of appeal and so cause notice on verification of the concerned record received from the forum below. It is seen that as per the information received by the LPO from the mining department, the appellate taxpayer has paid royalty such and such in the financial year 2018-19. But only this part only. There are nothing discussed, nothing distinguished.
The rest of the things are all.
But he has all.
Facts.
But these are the facts, my lord.
Sir, you can't be on your
No, my lord.
lens.
Only.
You can't see in your lens.
Only
You have to see in the lens.
only issue before your lord. Only issue before the adjudicating was that, my lord, whether the royalty is a tax or not. This is a matter in sub judice in Supreme Court in 9 judge bench of the Honorable Court. Your lordship know, my lord. In Indian cement sub judice. Besides that, my lord, we have taken the stand before the adjudicating authority that whether this royalty is a charge.
Even if Supreme Court, the matter is pending before the Supreme Court, whatever law at present is governing the field, that will govern the field.
That is
Even if it
correct.
is pending.
That is correct, your
That
lordship.
is also Supreme Court.
But things to
Suppose
be
the matter
decided,
is
there are
to
so
larger bench, whatever law at present is still, it will, if that is decided.
there are, my lord, so many lacunas, my lord. Why I submit only
They have dealt,
let him,
sir, they have dealt everything.
let him, my lord.
They have dealt everything.
No, my lord, I have not participated. That is the
No, you did not.
right from the beginning, my lord.
Did not. Is
When
there
the-
anything that says that your presence is a must? Very good.
No, when he is taking into consideration all these
Because
conditions,
you
my
have
lord, the
every,
earlier,
every document is present.
the
before the
earlier
authority.
occasion, my lord, this honorable court, my lord, allowed me to participate, directed him to dispose of.
Fine, sir.
Mr. Counsel, may I request you to come to the middle part of page number 5 of the impugn order.
Page no 5.
Page number 5 of the impugn order, appeal.
Yes.
You read the what besides.
Yes. That I admit, my lord.
Hmm.
In earlier repetition, I
You have been
admitted.
provided with opportunity, but when you have failed,
But I am not the
Everything
opposite.
is dealt, sir. Even if you are not there, your documents are there, your pleadings are there, everything is there.
Nothing
If
taken
ev-
in, my lord,
Everything is taken.
nothing
sir.
discussed, my lord, nothing.
And
On that-
discuss them.
My lord, on that line, I have a judgment, my lord.
How many time I should be again
My lord,
sent
petition
there?
of Honorable High Court.
Judgment छाड़ो ना. Judgment कौन करेगा? Facts speaks louder than anything else.
That is correct.
Judgment is not
High Court,
required.
my lord, on this
If
161,
facts is clear, no judgment is
Your
required.
lordship, my lord, 107, my lord.
Opportunity was-
Sir, nobody is disputing.
opportunity was-
Opportunity is given, my lord.
and then
No, that's why I came before this honorable court first time and made
You have come
application.
earlier also. How can you
Earlier.
last time? You have come earlier, you have been shunted there, you have been again shunted back.
No, again, I
Again you have
came.
come here.
They have not sent it. I came before your lordship asking for.
What is that?
material
Shunted
justice to
in
be
that
followed.
way.
I only said,
Shunted means what? They have just not they rejected your ideas.
no, well, natural justice to be followed. My only submission.
Sir,
that-
natural justice is, I don't find anything that is deficient in natural justice.
My lord, the review
When you are the appellant, you have just approached
approach, my
the
lord.
authority with all document. Why is the question of natural justice? It's not
The
a
last
court
time
kind of
when I pray before the adjudicating
So,
or appellate authority.
a appellate authority, does it require that your both persons should be present there and argue the matter?
Yes,
Like
hearing,
like court.
hearing.
Like court. In many cases, actually, in many
Opportunity has been
cases,
given, I am not saying.
that's fine. In many cases, without that also
My
possible.
lord, take-
Not to appear.
No,
If anybody is
that,
chosen not to
taking
appear,
into consideration all these contents, will earlier this request was disposed of, my lord.
Okay, you agree.
Your lordship, your lordship, at page 51 in the middle portion, your lordship, so far as the opportunities are concerned.
Hmm.
In consideration of appeal petition filed, the appeal hearing notice that issued to the bidder by notice number so and so dated 3rd March 2020. extending in an opportunity of being hurt and to produce, your lordship, my entire
Oh,
paragraph.
yeah.
These are
So far as the opportunity.
Well, I am not
And now
disputing.
your lordship.
I am not
it is
denying, Miller. I am not denying. I am
Again,
admitting.
so you are saying,
Well,
this
this,
is called oxymoron.
No.
On one hand you say yes, other hand say no.
Well, these
This is
first time,
oxymoronic attitude.
well, these pleadings were there in my earlier writ petition and the department was hard there.
Okay.
And taking into consideration the department is directed to dispose of Miller. That doesn't mean that they will take.
This honorable,
Okay, order is.
and this.
I file a note, Miller, short note. I
Please,
file.
And this honorable court has disposed of the earlier.
I file a short
petition
note.
As per law,
Okay,
and the law is very well. in
That-
section
that I-
161,
okay, sir. Give a note.
And there is no
I-
mistake.
Give a
applied.
note by tomorrow.
Yes, tomorrow and the judgment I will also.
Give whatever judgment. But prima facie, I am of the view that.
My lord, I am only seeking people also whether.
Even
the
if
judgment
not
has to be
there also
followed.
can't, that is
Because
not
what my
necessary.
learned friend is arguing, advancing
you are
the
the-
argument that was
you are
there in
the-
earlier
you are
writ petition, Miller.
You are the applicant.
Pleadings were there, available to the earlier writ, Miller.
You are the applicant.
Since disposal is as per law. This
That
honorable court has
doesn't mean
directed
that
as per
we
law.
will not
Nice.
follow the.
Nice.
In
We'll see in a
tactics
better case.
statute, representation.
We'll see in a better case.
No, in a better case, you also find it can be made better case. For your lawsuit.
No, I'm not saying bad case. I'm saying the contention you are raising that is not finding any place in our heart.
And if you also see on merit also 74, they cannot proceed without prior notice, Miller.
Notice.
Those are the.
Sir, everything is there. Sir, we have not-
161 so
We have raised before the appellate authority, did not consider.
Thank you. Next,
There are 8, 9 and 10, 3 matters.
8, 9, and 7.
Disposed of your.
We are discussing, we are passing it later.
Item 11.
Give a right to
I'll-
by tomorrow, don't delay.
Mr. Mishra also can file a write-up. If, no, he, highlighting the provisions of law.
Item 11, just now I have received the copy. And here the assessment order has been challenged, your lordship. I have many argument. I have so much of praise argument, your lordship, in this case. So,
Praise
your lordship,
Every day.
because I have not argued this on this line prior to this prior to today.
Any other?
This writ petition is not maintainable, your lordship, because it has been filed after the statutory period of limitation of filing of appeal. And this case is well-
friend is ready to argue, so let me argue, let him respond. That will be.
Let him, you are the rest.
Yes.
Let it be tomorrow. Because just now I have received the judgment, I have
Okay, tomorrow.
everything, but just.
Let him-
things I have go to-
Tomorrow. Day after tomorrow.
Yeah,
So you will get a chance to.
your lordship, because, your lordship.
No,
because-
don't argue further.
So that-
Okay, you have already said, we are giving you time. Okay. You can't handle it.
You cannot even handle.
because I-
Right, your argument is here. It cannot be handled.
I have got the opportunity to argue against my lord and CBA. on
Once
this point,
here,
and
every
this
day-
is the beginning point, your
You are
lordship.
every day you are arguing against it.
On this.
Oh, this issue. It is
Get ready,
special.
we are also ready.
Delay. Next.
Yes.
Item 12.
Well, sorry.
In absence of second appellate, writ petition has been filed.
10, 20. Or 100.
100%.
100%. 100% delay.
Delay ଅଛି.
Your lordship.
କେତେ delay?
Only delay, ma'am.
କେତେ delay?
3 months.
3 months.
100%.
Your lordship, also, a single day delay is equivalent to two.
अरे सर मना में delay decide करियो ट्राइब्यूनल आमे काई मुंड करियो हां और ये तो decide तो करा होनी तो delay काई decide करियो फाळे रहियो तो पूरा से decide करू सब यदि कहै वाला सब decide कर दो तो फोरम लूज करियो मैं चाहूं I should lose forum. Next.
Item 13.
Item 13 will not 100% against the release there.
13 and 14 both 100.
Attachment is there. Miller, sir.
केते delay अछि
187 days.
187 days. But attachment is there.
You want-
100%, that is 100%.
if you paid already
Yes, some parts have been paid. Rest of the month I will pay. Miller.
so where is the attachment order? This one, annexure 6.
Yes. Next of 6.
On deposit of 100%.
Okay, on the deposit of 100. Where is your application? Application you file?
Yes, mistake.
The operation of annexure 1 and 2. Annexure 1 and 2 lekha the order are dated so and so Slash annexation लिखिए ଏମିତି ଆଧା ଆଧା କାମ କରିବି ପୁରା କ୍ଲିୟରଲି ଲେଖିବି order dated so and so passed by so and so ଇଚ୍ଛା ଲାଗିଲେ annexation ଲେଖି ପାରନ୍ତି ନ ଲେଖି ପାରନ୍ତି slash annexation ଲେଖି ପାରନ୍ତି ବଟ୍ ପୁରା ଲେଖିବି ଏମିତି annexation 1 annexation 2 ଏମିତି ଲେଖିବି this will clarity no this will stay of the operation of the order D9 2022 passed by additional CP and GST officer, CP and GST circuit and also and one next
14 is same,
14
14 is same, delay.
14 is same
Lordship on
similar issue
No attachment. No attachment.
No attachment there,
No attachment.
only 100%.
only 100
the Lordship on 13 and 14, I am appearing for opposite party number 1.
Avinash.
Item 15,
15 millets, we are challenging the GST first appeal order and 10% pre-deposit has already been made.
no delay.
There is no delay. Similar order of your lordship. Listen, those order my name reflects as Mr. Itishri Tripathi instead of Miss Itishri.
Oh. Whatever comes. Can't change the this 10-20 na
Yes, Lord, 10-20. Oblige.
item 16,
May I please, Your Lordship? Your Lordship, this petition is against the first appeal order. Your Lordship.
and delay
No, Your Lordship.
10-20
10-20.
next
17,
My please, Lord. GST tribunal is not functioning, my lord.
then same order
My lord.
10-20
My lord.
10 10-20
10, my lord.
item 18,
Let the notice may kindly be issued.
notice not being issued
No,
2010 में
2010 ରୁ notice issue ହେଇନି
notice ହେଇଥିଲା dismiss ହେଇଯାଇଥିଲା ତା review petition ହେଇକି allow କରାଗଲା monetary limit ପରେ dismiss ହେଇଯାଇଥିଲା
review allow କରାଗଲା
ହଁ allow
so will be
question is not been framed
will be hearing the review
it is a final hearing IT appeal review is already
sir ଆପଣ ଉପରେ କୋଉ dismiss ହେଇଥିଲା
review disposal ହେଇଯାଇଛି with a direction that IT will revive
where is that order
23
oh it's okay IT issue notice
requisite within 3 days
issue notice to law question of law
question of law
page 8 আমার কোশ্চেন অফ ল যদি 2 লাইনে ন করবে আমি দেখিবিনি কোশ্চেন
Okay.
অনেইবিনি 2
না,
দিন
দুইটাই কোশ্চেন আছে বেশি
কোশ্চেন
নাই।
অফ না দুইটা কোশ্চেন না 2 লাইন রে সারি
2 লাইন করে বনি দেবি।
এতে লম্বা লম্বা হিন্দি কোশ্চেন অফ ল বনা যায়
ନାଇଁ,
কোন
issue
পরীক্ষাରେ কোশ্চেন বনালে এতে লম্বা হেলা
ନୋଟିସ ଇସ୍ୟୁ ହେଲା ପରେ ମୁଁ ଦିଟା ଲାଇନ କୋଶ୍ଚେନ ବନେଇ ଗୋଟେ ପେଜ
ଆପଣ
ଦେଇଛି।
ସମସ୍ତ କହୁଛି 2 ଲାଇନ କୋଶ୍ଚେନ ଅଫ ଲ always 2 lines maximum 2 lines
ଆଜ୍ଞା
it can't be 3 4 5 6 sentences
ନା
why are you writing the facts and circumstances of the case ଲେଖିବା
Issue-
ଦରକାର ନାହିଁ
13 ମସିହା ଫାଇଲ ହେଇଥିଲା 23 ରେ ଯୋଉଟା ଫାଇଲ ହବ ସବୁ ଠିକ ହବ।
brevity
Yes.
brevity is the soul of it
Yes, yes.
पूरा शॉर्ट करेंगे शॉर्ट आंसर मिलेगा
आगे।
आंसर मिलेगा इधर क्वेश्चन कोन फैक्ट्स कोन जाना पड़ुनी
ଆଜ୍ଞା।
फिर आपण पढंतु क्वेश्चन टा कोन पढंतु आ मते कहबे तो शॉर्ट कट करी कहबे रीड द क्वेश्चन
Let issue notice that.
यार यू रीड द क्वेश्चन
Okay, okay. First management committee. That page 8 below. Registration as 2A and the assessment is through the whether the facts
फर्स्ट क्वेश्चन
first question. Whether the facts and circumstances of the case, the learned ITA was right in holding that there is no case of revision under section 263. Once it is accepted by the department that the income of the assessee is exempted under section 11 of the act by your registration.
लास्ट से पढ़ला पर आपण से क्वेश्चन कोन पचालने मते कहि परिबे न देखि कहि परिबे क्वेश्चन एंती आवा कथा न देखि राखी बंदले क्वेश्चन कहि उतबा आपण ए क्वेश्चन पूरा
बड़ हो गला।
फैक्ट्स बड़ा माने फैक्ट्स क्वेश्चन काई खाली क्वेश्चन मार्क थोड़ा
I'll
क्वेश्चन
prepare it.
नहीं एटा फैक्ट्स रे क्वेश्चन मार्क लगे दी एंती क्वेश्चन ना एटा को पूरा क्वेश्चन भलो कर हम टाइम जल्दी देबे आजी आजी
बनी के दे देबी।
आजी बने के देबे क्वेश्चन काट देते क्वेश्चन सब बने के देबे दुई लाइन मो किछि बन जोटा के दुई लाइन लिखियो एते गप्पा लिखुन
I have only 2 questions.
Amongst the question बनाना be careful, make it as brief as possible and avoid irrelevant question. Only question which is substantial in character. I want to सबू facts को लेके last में question मार देंगे substantial मत पूछो एमसी पढ़े हो next
Say question page 4 page 4.
Item 19.
Whether on the facts page 4.
question से दे देबे before 2 o'clock
Okay.
अरे बस के लिख देबे ती
हाथ लिखा देबा पर टाइप
କିଛି ଅସୁବିଧା ନାହିଁ ହାତ ଲେଖି ଦିଅନ୍ତୁ ଆମେ ହାତ ପଢି ପାରୁନୁ ନା ଏତେ କଣ କ୍ୱେଶ୍ଚନ
only 2 questions.
ସେ ଟୁ କ୍ୱେଶ୍ଚନ ଦେଖିବା ନା हेबिट अच्छी है लंबा क्वेश्चन बनेगा on the facts of the case the letter justified allowing carry for a question sir substantial question है
Second ask you.
fast and बिल्कुल question हुआ है
Second ask you.
उधर
Capital expenditure claim. ITT was justified in allowing the capital expenditure claimed by the SSC by application
2 or 3
2 and 3rd.
এটা भी नहीं थर्ड भी नहीं
Third,
only 2 थर्ड भी होगा सर आईटीएटी काहे की कला हेड क्वेश्चन आईटीएटी काहे की रिजेक्ट कला क्वेश्चन अब गुडे को सेक्शन रॉन्गली इंटरप्रेट हला कि को गुडे एक्सपेंडिचर ते रॉन्गली तक निया गला दैट इज क्वेश्चन नॉट कि अब आईटीएटी वाज होल्डिंग आईटीएटी हैज हेल्ड इट रॉन्ग दैट इज द क्वेश्चन
ठीक है कर दे
सब्सटेंशियल क्वेश्चन
बस कर
नेक्स्ट
Item 20.
Made result.
9 9 both
Item 20 and 27
yes
as same. And
20.
this is a textbook example.
sorry sir
Item 27 regarding the quantum which was challenged before this Hon'Ble Court.
recovery
Now they have imposed penalty during the pendency and stay operating. This is a textbook example, my lords, how the officers do not respect the order of this Hon'Ble Court.
where is the stay order
Lordship may kindly see.
the last 55 page
Yes, yes.
Yes, yes.
Eta na eta hochi. Lordship may see Annex 13, page 54 in item number 20. 54
It is annexure 11, I think.
Last election.
Annexure
Last,
13, my lord.
You
11.
have written it, right? 13.
So-called notice, এটা হলো proposed variation. সেটা আপনাকে দেখো স্যার দেখিবে।
Correct.
Yes. Annexure 11.
13.
No,
Item
13
20.
इथरे लिखा है, but book mark देखो 11.
আজ্ঞা
इथे माने wrongly.
এটা কোন কেটে না।
When there has been direction of no coercive action shall be taken and matter is pending.
Wait, I am not finished. Don't be so anxious. Then when
There is a direction, but no coercive action.
yes, now
In another matter, there is.
another matter more. Same as assessment here, same SSC. The bench order, this Hon'Ble court order, no coercive action. Now they have imposed penalty.
No coercive against and no coercive action.
So far as the
Against which order?
against the order of the assessment.
Where is that order?
Yes, that order is lordship find in annex that item 27, which was challenged. That your lordship will see 3-4 at page 2730. The to annex 3 and 4 at page 20 to 36.
Page 20.
Yes. Assessment order.
So this order and
Yes.
the stay was against this order.
Yes.
And
No coercive action.
And they have proceeded with which order? This
No, they have proceeded. Lordship will kindly see. One so-called notice. You have already imposed penalty. Lordship will see annexure 1 and 2.
The so-called
No, they have imposed penalty of 20 lakhs. So-called notice.
on the same
God.
issue.
Yes.
On the same.
Yes, I am ready. I am placing it. Lordship will kindly see. Order under section 271 AAC,
Annexure 1.
annexure 1. Therefore, keeping in view of the provisions of law, penalty proceedings were initiated under section
How can
271.
you say when there is a stay operating against you?
Exactly.
How could you proceed with this proceeding? क्या आप लोग क्या सब आजकल बड़ा powerful हो गया? The income tax authority has become more powerful than police officer nowadays.
Probably that is a misunderstanding.
I have given.
I don't know who is your Akka orders all these things. I don't know.
Lordship,
Yeah.
keep it to mother day. I will take it.
Regularly happening.
Lordship,
पता नहीं
Lordship,
you just-
it is
you
not
don't-
necessary.
Let's see this order of the order of the High Court stay order.
No, yes, ma'am. That is there. That is there. My lord. That is there. I didn't concede. That is there.
And you have also reflected in the order that if you read that in your reply dated such and such, wherein the Honorable High Court of Orissa has passed an interim measure that no coercive action shall be taken during.
Lordship in another matter, Lordship, while issuing notice, because the time
That was.
that was ending for.
You are
initiation of
getting
penalty.
time under section 153.
For initiation of
153
penalty
is for the
proceeding, that
limitation.
time bar as per the faceless system, my lord, that was time barring by 30th of September.
So you'll see
Probably
that
for
the-
that, my lord, that is.
the
that is-
No,
machine
they
had
have
issued
completely
order.
misconceived the section 153.
Are you using AI, artificial intelligence? Sir,
Lordship.
AI.
AI.
AI, are you? So then artificial intelligence को हमें कुछ करने को होगा।
Lordship, kindly.
Faceless तापरे AI use कर दियो। Notice बनेगा वो AI बसीकरी। Notice पड़ेगा फिर बसी। अब ऑफिसर को तो faceless AI तापरे assessment officer भी artificial intelligence ने बना।
Lordship,
This is-
and your lordship will
Keep it
find.
to some
Just
other-
a minute. No, it's not necessary. Lordship will kindly see. This is the quantum assessment 11558 is covered by your lordship's order. Lordship will see that 2 days time for which the or this honorable court
No,
gave
that
the
is,
no. Just a
You have
minute.
to explain why you have, despite the stay order, why have you done? Explain.
There is the again
The learned, what is who is the officer?
assessing officer, my lords, of the faceless
Learned
unit.
assisting officer
faceless,
has
that
to
is
explain
faceless, Lordship.
How se
Explain.
faceless is jana officer ଅଛି ନା.
As to why the annexure 1, the order under section 271 AAC 1 of the income tax act 1961 has been issued to the present petitioner despite the stay was operated, despite a
Despite no coercive action, my lord.
Despite an order of no coercive action passed by this court on 24/2022.
Yes.
You explain it. Then we'll hear it after that. And first you explain this.
Another matter may come along with that, both the matters.
No coercive action in this matter, item.
Already no coercive action.
They have already violated it.
They violated.
Yes, my lord.
No coercive, then you have to explain it. Right? You have right.
No, we are sorry, this is.
In every case.
Again, what?
In every case.
And you have also interpreted it that mere filing of writ does not preclude the authority to proceed against. Yeah, it has been reflected in the order.
That
It
is,
is not mere filing it. It is armed with an order.
yes, I do concede, my lord, I will not.
Next. List the matter on
Both the matters, item 27 and 20 may be tagged together.
13.
13, yes.
Next.
21.
Obliged.
May I please, my lords. Because in this case, the lordship may kindly say,
Tell your officers, sir, if this kind of thing, I'll call them to court and make them stand the whole day here. Tell them clearly. What is this? You can't just,
My lord, just.
you, whenever they are violating, you are taking them to anywhere you like. If they violate, where do they go? They come here.
your lordship may kindly turn to page 33 of the brief, my lords. Because
Yes.
annexure 1 is judgment dated 26/10/2021
They've
passed.
not refunded so far.
They have not refunded. Consequential order also, your lordship will find annexure 2 refund claimed is, because they have determined my refund payable is 99,98,506. Where this is followed by annexure 3 and 4. Despite of that, no refund is granted.
They shall consider Supreme Justice. This case is going to Supreme Court.
Your lord, already refund has been stayed by Honorable Supreme.
This will stay of religion.
एक case है, sir.
Again, 26/10 के ऊपर देखो, final order
Yes,
dated 26/10/2021 in STRB number 6, your lordship
Hmm.
kindly look
Yes.
on to page
Hmm,
14, 14. STRB number 6 of 2005.
Order dated?
It is continue order to morning, but it has been continued.
Date of order? 23 to
20th March.
My application was lying over since 21, and after 2 years, anyway, now that is the order. Honorable Court has.
I do, your lordship, because
Okay.
it is Supreme Court, then my lordship has
Okay.
give the
I'll
power.
consider the state submitted. See if there is a stay.
Today the case has been listed, so I have
There is a
I have got the
non-private
opportunity
refund
to
from the
submit.
respondent.
Anyway, you did pursue anyway.
Then, by the Supreme Court,
Also,
with a special link, petition.
Civil diary number.
সেগুলা ছাড়ো, আমি হাইকোর্টে রিটার্ন So matter to lie over subject to.
on the same cause of action, the petitioner has moved an application, the applicant has moved an application before NCA to release the refund. And there also would have produced this order, and Lawrence, NCLT has stayed this matter.
This is.
Same cause of action.
The NCT president also.
Again.
Say instruction I'm doing that anyway. But now that.
Because at the same time, simultaneously two proceeding on the same prayer, NCLT petition is with me, the same prayer, before NCLT as well as before me.
After the.
Signed again.
Chennai.
Also, the matter is disposed of by the Honorable Supreme Court, full stop, with parties to mention for this court for listing post disposal of the Supreme
Yes,
Court.
published.
22.
Yes.
Item 22 and 23 kindly next to Mr. Patra is out of station. Mr. Patra is out of station.
22 next week.
Next week.
My lord, in item number 23, I am for the caveator. I'm one of the objector.
ये जितना है
My lord, I pray let a copy of the
time मांगू से मैं दे देता
copy of the
हाँ,
writ petition be sir.
हमारा caveat कहाँ पे?
Objector. I'm opposing grant of license.
Okay.
I'm litigating all
So
through.
this
next
matter on eight has. Next. Both 23-24 both.
No,
Vice
and
Oh, sorry, 22.
24.
Seeking adjustment of license fee and MGQ during the closure period. Admittedly, the shop was closed because of unruly mob.
Similar order with us?
Yes, yes.
Can you?
More than copyright. I
And that order which has been referred to in that, my lord, also I have the copies.
It is directing them to represent before the.
Yes, and my representation is also pending before the collector. He has to take a call.
this is something different. Lifting of something.
नहीं 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 पढ़ो पढ़ो और अब ये जो चीज मिसलीड कर रही हूँ
No, representation is pending before the collector. It is pending before the collector.
I have made a representation to the collector.
Annexure 6.
Press you can give a press representation if
Yes, in view of the judgment, I will cite all the judgment.
Beyond.
This school, 4 weeks from the date of presentation. Next.
Item 25.
25.
I have for restoration of dismiss for the read of it.
Okay, let's go. Let's go to the. Let's go.
Item 26.
26. I'm appearing from the opposite party. I think we trying to fight something.
Sir?
I'm appearing from the opposite party.
Opposite party, Mahanadi Coalfield. You always say, sir, opposite party, Mahanadi Coalfield, you must say this. Opposite party के अंदर कितना थी वो हमें कितनी जानी हो? पूरा कोई भी ना हो. Sole opposite party, many opposite party आते हैं. हाँ.
All the opposite.
कोई भी ना हो, तो नौकर लेकिन दे. So you want 2 weeks time?
I can't.
Give a copy, Mr.
I have got the copy.
Yes, yes, I have. Interim order to continue. Interim order to continue. Both the matters, madam. The tag 2 matter.
Oh, tag also. You file your reply within by 14. 14 is the next date of listing. 14.
14. Can it be after vacation?
After vacation? Sorry, 14 no, October. Okay. 30th. 31st.
31st. Great.
Next.
Item 28.
28 matters, that matter, Acharya, your institute, your lordship direct my friend to file affidavit as per your lordship direct. They have filed today, in fact, just now they served a copy.
Respond?
I will respond, my lords.
That's for the application. File.
But I pray for any day after vacation also.
First November?
1st November, yes. Interim order to continue, my lords.
Next.
Item 29.
Legal lordships. A demand was raised for the assessment at date 11. That is Annexure 4. Now, this demand was never placed before the resolution professional nor before the exchange while it was undergoing the IBC.
It has been sent to you.
It has, Lordship may kindly see. Income tax appellate tribunal on the annexure.
See you, but this the tax demand when the matter is in the IVC proceedings,
Yes.
So,
And that has been admitted.
admitted
Yes, admitted. by-
Lordship kindly see, annexure 12, my lord senior has, client of my lord senior has already submitted rectification application. before the
Nothing,
authority.
I am not
That has-
pressing it.
That has been,
Okay,
that has.
I am not
been
pressing.
pending. That
Your
has not
entire
reached finality.
effort,
But the thing is, when
That has not
matter is
reached
pending,
finality.
How he loses this?
it has reached finality. You have, Lordship may kindly see, annexure
you-
1.
Once rectification
Let the
application
liquidator
is
take
pending,
No,
my lord,
no,
he himself, he
I am
himself,
not pressing
the
it,
petitioner
okay?
has
Shall
filed.
liquidator take it?
He has been noticed, he
Sir,
has been
sir,
given
sir.
notice by
No,
the
no, no,
department.
I am not pressing
You
it.
produce the document so
No.
that we can rectify this.
No, no. What you have produced, I have given. This is your, how many times you have taken adjournment? Lordship may see the order sheet. Avoiding all in the guise of this notice you are proceeding to nullify the order of the ITIT where you have admitted. Lordship may kindly see page 17. They say in the counter affidavit that it is 0, but again charging interest. Lordship may see in the next page. Next page, the liability of rupees 6 crore 98 lakhs 24,230 stood frozen, and no such claim can be made against the SSE. Now they have imposed interest.
What is that order?
That order, Lordship say, annexure 1, page 17. 17 ने कौन कर ले last आर्ट को साथ देखो तो Lordship may kindly see computation of income and tax 234A सेटा होची advance tax रहिए ता सागरे कोनसी नहीं and resolution plan रे भी कोनसी रकम रो provision नथिला resolution plan as per the judgment of the committee of creditors versus that Justice Nariman's judgment matter through his authorized representative versus SR Steel matters. There they have said that the resolution plan is the wisdom of the committee of creditors. Nobody else can touch it. Even the NCLT has no power. Well, Lordship may kindly see next page, page 18. For a moment, may kindly see.
This is balance tax report 9 crore 53 lakh.
9 crore. Where is you say that the quantum is frozen. At the same time, we are imposing interest. And they say, just a minute. Counter affidavit. I am showing the counter affidavit. You cannot go beyond your pleadings. Page 4. They are defending. Then, page 4, the petitioner is very much aware of his facts, but trying to quote misleading facts regarding interest and demand raised by the impugned order dated 7/2/2023, that is annexure 1. Considering the above facts of the case, it is clearly apparent the impugned order dated 7th of February 2023 and demand raised therein is legal, just and proper. Then next page, Lordship will kindly see. Middle portion. Next page, page 5 of their counter affidavit. Further are discussed above the interest is and inbuilt factors applied on taxes along with cess automatically.
तो बैंक से भी आगे निकलेंगे.
आगे ये बैंक रो आगे. And at least 12 times the revenue has taken time. Now they are.
What is your answer?
Lordship may leave it to the department to consider and pass the order.
No,
because
no,
that is there.
No. Again, no. This is a game.
Sir, this is not right order.
I am giving the judgments. Monet Ispat by Justice Nariman Mallards. It will override. Duncan Industries. It will override. And
so this is special act, no?
Yes, special act. And because of section 238 of the IBC. This cannot be managed. Go on. Every time. Monet Ispat, Lordship may kindly see. Monet Ispat. Duncan Industries. Okay. That. I'm just placing Duncan Industries by Justice Gawai, where he said, the last page, the sum and substance of the above discussion would be that the provisions of IBC would have an overriding effect over the T.
Without saying that.
Without saying
record
that,
for
yes.
this.
Then
There is no
Ghanshyam
general record.
Ghanshyam Misra, if a amount has not been placed before the resolution professional and has not been settled, then you cannot saddle a successful resolution applicant to face that. This is what my submission. Other judgments I am giving for only for lordship's convenience is not necessary because your lordship is aware of those judgments. Lordship may reserve the order and quash.
Thank you.
Same is the next item, 30. 30 is about the TDS. Same. TDS, amor course provision nahi. तथापि कौन ना कहीं तो मैं काटिलनी the matter is the same balance. 31 is something else. Amori ke who appear to say the item opposite
If you want to give any note, Mr.
balance, I'll give a note
By tomorrow.
by tomorrow.
31.
Definite.
31, I have today, Milord, I have received two huge paper books of a counter from Mr. Rai and my senior Milord. So I have to respond it. 31. I have to respond it, Milord. Though I have this court has allowed time, but I need further time 2 weeks to file the counter because it needs Milord to go through all this. I am for the revenue, Milord. Yeah, tax.
Lordships, I am appearing. Lordships, I am appearing online in item 31. Lordships, I have moved an application. The application number is 15589 of 2023. Lordships, this is an application for impediment. So, Lordships, in fact, I have an interest over the property, and my matter is in fact pending before the civil court, the civil judge, and Lordships before the DRT. So, I have an interest in the matter. I'm requesting that I may be impeded in this.
Madam, your implement application has not reached to the court.
It has not reached. Lordships, my associate would be there. He'll hand over physical copy. In fact, we've served upon the parties.
It is
And,
numbered.
Yes, it is numbered, Lordships. It's 15589 of 2023. Again.
I am appearing for the opposite part number 3, my lord.
He is asking for
Yes.
Because I have to respond fast because
Yes.
otherwise, Milord, it will.
So you give a copy to him also. You give an application.
For the petitioner, the main opposing party is the revenue.
Yes, Lordships.
Secured creditor.
But he wants to.
Sovereign debt. Yes.
So we'll hear that on that day. Implement application is allowed. Implement application filed by.
Lordships, this is filed by one Siddhant Singh Deo. So, in fact, Lordships, there's a little history behind this. So, this property, in fact, happened to be my father's and my grandfather's, and thereafter my grandmother's, which was in fact sold to my brother-in-law, who's opposite party number 2 or 3.
So
And
Siddhant
Lordships, in
Narayan
fact, for
Singh
which I had yes, I'm
Narayan Singh Deo.
Siddhant Singh Deo.
Page
Siddhant
3.
Narayan Singh Deo.
Page 3 it is there. Siddhanta Narayan Singh there.
So he is residing in New Jersey.
He is in the USA, Lordships.
So he is representing him here.
I'm representing him, Lordships, Siddhant.
That's 2 weeks.
2 weeks.
Keep it after vacation so that.
After vacation. That will come on 6th November. 6th November.
6th November.
6th December.
I am for OP number 2.
But I'm for the petitioner.
Give the short memo part to your appearance. कार पे की जाना पड़ेगा ना लिखी देते हैं.
Entry model to continue.
Yes, yes.
Entry model. Okay. We are appearing for the opposite number. We have already filed the file.
No, I am giving that slip. No.
Sleep is making it. I'm not sleep the confusion of it. Those are will say
better actually. Multiple persons are here.
This is the copy I received today.
This is like a convenient compilation.
Now it has become 1,000 pages. There is a requirement of convenient compilation. Otherwise, it is very difficult to handle. And his counter is still there. His file also.
So the brief looks fat, my lord. Brief looks fat. The question of law is.
The word brief has lost its significance.
And you don't know why it has been so bulky.
So your lordship has already handled those 24 volumes.
Oh my God, 13,000
Right.
pages.
Yes, sir.
It is uploaded, you can see that.
Today we have got my name. I have given my appearance.
Yeah, please.
OP number 3.
Next.
Item 32 only 2 is time. Mr. Pathak is on.
Yeah, I am for the petition.
अरे এটা গোটে চাকরি করদো না দেখো বেসিস প্ল্যান্টিং ইজ yes
Maybe.
What is the issue?
Lord, the issue your lordship has elaborately have explained this fact earlier that your lordship supposed to admit the questionnaire, but I order it has not been reflected the questionnaire law so far as today Milord has not yet been admitted. However,
OMC
Indian so lordship, before I place the question of law, your lordship remember
Only one question of law.
only question whether the 147 proceeding
143 of ITA treating the region required by the change of opinion.
yes, whether this is to be a change of opinion or not, that has to be seen because tribunal
This was framed.
no, that's the only notice I issued. Suppose you are by A is substantive.
Don't consider the by the note of submission.
Well, I have already filed my written note of submissions with the case laws.
Okay. Milord, I am just to place the case with supporting judgment. Yes. Milord, your lordship.
If my lords, I am ready with the matter. If my learned friend wants to go ahead, we can.
Yes,
It's
I
a
am
short.
also ready. I am not wanting.
He's ready.
I am also ready.
Okay.
No issue.
We can. Please.
Before lordship start the case, your lordship for a moment to lordship 147 because of far-reaching consequence about these issues.
Yes.
The situation has been changed after 1089. Lordship see the 147 per moment.
Yes.
But, if the assessing officer reason to believe that any income may subject to provision of section 148 to 153 assess or reassess such income and also any other income chargeable tax which has escaped assessment and which comes to the notice subsequently. That is not important for my case.
You are reading 147?
147.
Hmm.
Escape assessment.
Yes.
I'm starting from again. If the assessor have reason to believe that any income chargeable tax has escape assessment for any assessment.
147. We have something.
147, are you
Yes.
reading 147?
Yes,
You are reading old book, I think.
it is a
From
old
this
case.
book, from this book.
Oh, that is not.
You are reading one which edition?
It was prior to 1421. Moving Babeda portfolio fast. ନୂଆବେରି ନାହିଁ ନୂଆରେ ତଳେ ଲେଖା ହେଇଛି ତଳଟାରେ ଅଛି ତଳଟାରେ amendment ତଳ amendment ଯୋଉଟା ହେଇଛି ତା ତଳେ କୋଟ ଅଛି ଏଟା ନୂଆବେରି
Sir, 147 ଦେଖନ୍ତୁ ନା।
ହଁ 147 ତଳେ କୋଟ ହେଇଛି prior amendment ତଳେ ଅଛି
ଓ prior amendment ପଢୁଛନ୍ତି।
ହଁ prior
ଓ ଆଚ୍ଛା ଆଚ୍ଛା। You should tell me. Reading 147. Prior amendment.
କି ପତା
Yes, now it. Yes, return to.
yes Rigid to believe that any income chargeable tax has escape assessment for any and which comes to the notice subsequent. The line deduct
Well, I'm sorry, I'm unable to hear my learned friend.
officer passed any reason or passed any issue in this plot so far as this issue is concerned in the assessment here. In referring the 147 plot, the assessing officer has issued notice to the petitioner to explain this issue. What is the issue? Just reflected in lot tribunal order running page 13. He has reflected region in view of the GK drives. The region is there. Page 13. Yes. Paragraph 8. The assessment notice has noted as under further verification record, it's revealed that as per the information available in the record, that the assessing company has incurred and debited an expenditure of rupees so and so lakhs towards legal constituency and commission, on which no tax is deducted under section 195(1) would not be eligible for deduction under the head of profit and gain business or profession under 40 AI of the Act. Beside the above one verification assessment has been revealed that closing stock so and so. The fact remain, it is admitted fact that earlier assessing officers not consider this issue at all. And if your lordship see the assessment order, earlier assessment which has been compiled, completion has been given by the petitioner. He has enclosed that assessment order. Lordship kindly see the assessment order in compilation. Come filed by the petitioner. Sorry, mal respondent. Bound volume. There is two volume. One is case laws and other is my lord other relevant issues. Page
This is by Mr. You have
Mr. Jali has.
Jali.
Please, my lord, I have filed.
You must in below you must write the name of the lawyer, otherwise you get.
I am so sorry, my lord. I'm sorry. My lord.
Yes,
You know the Delhi High Court practice till you are doing that.
No. In fact, my lord, my colleague, Mr. Jena in Cuttack had filed this. He should have put his name. I completely take it, my lord.
Page 38.
Page 30.
This is relevant to assessment 8-9. It is not the original assessment under 143 of the Income Tax Act. Here, lordship see in the next piece. The heading is payment of election duty disallowance under section 43B. That has been considered. Then let's keep up this next page. Expenses on foreign travels, executive chairman, managing directors, corporate vice chairman, so and so. And the next page, my lord, export promotion business, foreign and traveling expense, so and so, so and so. Then next page also, this has been reflected and order has been passed. No, here it has been considered so far as the deduction of tax under section 95(1), read it on 40AI of the Income Tax Act. Then you'll also see, this is the fact, my lord, the fact remains, my lord, it has not been considered while passing the original order assessment. Subsequently, it has passed as the act says, my lord, subsequently it is found. Then he has the liberty to issue notice and record it. There is no issue. My lord. Now you'll also see what the tribunal, my lord, travels on the rule. Tribunal not confined to only issue without coming to the factual issues. Not he simply say relying on the judgment of culminator. The honorable the London tribunals say it is a change of opinion and no tangible material found or in the record of the assessment. Therefore, it is not permissible. It not touch the factual issue whether it is permissible, whether the deduction is permissible, whether deduction is required or not. He has not taken any consideration of this. You will also see from first page to second finding also you will also see it start from paragraph 9, internal page 13. Perusal of the record regions so that no here record
opinion must be treated as an inbuilt test. Check every power.
No, you will also page 13.
No, I've
oh, achha.
I've already read that.
Right. In period record region so that nowhere it records any phrase tangible information which comes notice of the assessment after completion assessment 41, 43 rated for the assessment 9-10. Before record in region, rather record region.
What is the tangible information?
Not required. Now the law has been changed by the superior judge.
At that time, not required.
No, at that time.
Reason to believe.
No, that tangible matter referred by the Kelvin.
I'm not on that. At that point of the reason to believe was.
Reason to believe there, and the Honorable Supreme Court comes to conclude there must be a tangible material. Now, my lord, if your lordship see the act
that
itself,
the law has been slightly
changed or
not changed,
modified
not
to the modified to the subject to yes.
Reason to believe was
To the best what is state based what is modified to moderate way, to the moderate way.
Objective
To the moderate way to arrive the aim and object of the legislature under 147.
And
Now-
also to discourage the erring official to go ahead with the
Therefore, 148 and I introduced 1421
Yeah.
to close this issue. Now, your lordship see the whole tribunal totally relied upon judgment of the Honorable Supreme Court. Kelvinator. Your lordship nowhere he has not finding whether it is permission.
Do you think it is wrong?
Yes, my lord. No, my lord. Because the acts your lordship know in this fiscal statute, nobody has go beyond the statute. He has not my lord, interpreted even the statute. So, while fiscal statute is concerned.
When the Supreme Court in a particular statute, a particular provision says something, there is some, you have say clarity deficit in that particular provision. Can the Supreme Court judgment not be taken as an aid to that?
Correct, my lord. Bow down. But fact remains, my lord, whether the act is challenged, the virus having challenged is 147 to arrive in this calculation.
Challenge, sir, for clarity.
But clarity, but so
clarity, if they see this, when the Supreme Court judgment has been relied on for clarity purpose.
thereafter
If
Supreme
right
Court says,
is
thereafter also
right,
Supreme Court says, Lord. Now Supreme Court, I am coming with the Supreme Court judgment even thereafter. Lord. Now your Lord see, I am just compiling two judgment, Lord. And third issue is not the petitioner case is not. Earlier, this honorable court has passed the order in favor of the assessee. Your Lordship, see that order for a moment. What was the order?
Which one?
That is, my Lord, see page 10 of the compilation filed by the respondent.
Page 10. The compilation or this one?
Compilation. Is related that it is a pass by. Say similar issue has been considered by this honorable. What is the order and what is the ratio decided? Let us see first.
Page 10.
Page 10.
Yeah. Page 10. Which
Yes.
judgment was it?
While admitting the question is similar. So for my question now and the question,
Which
blood capital A, whether fact and circumstance are justified.
No. You are saying page
Page
10.
10. Page 10 is the compilation filed by the respondent.
This one.
There is two compilation. One is judgment, another is not. Tutor upon the kill order ta juta dikhle.
Eta.
No, order juta dikhle.
Manoj, I have filed written submissions and a compilation of case laws.
When you are filing something, sir, please explain your local counsel who can file it better, and he should also write his name and also volume and explain everything here.
I am so sorry, Malaj. It
Otherwise,
seems.
there will be confusion.
I am so sorry, Malaj. I
Your
apologize.
foreign partner and Indian partner should have some. I mean, they should be on the same page.
But we should all be in tandem. We should all be in tandem, so there is no change of opinion.
Yeah, so they should be everybody in the same page.
Grateful.
Yes, next.
I mean, page 10, your Lordship.
Page 10. This is High Court of Orissa.
Yes. This earlier case of the petitioner, which has been considered by the Honorable Court in against the revenue.
What? Considered by?
Considered by the Honorable Court, sales some issues passed against the revenue.
Against the revenue. So where is showing this?
Yes, that is what my point. Now I come to the point. After placing that, because it is not ratio has been laid down, your Lordship, see. The question is same, Lord. I don't want to repeat it again. Now let's keep it off over. Very important to place the paragraph 3. On perusal of the impugned ITIT reveals that in original assessment proceeding, the assessee had produced the various document books of account on the basis on which the assessment order passed by the assessor noted in paragraph 14. The assessee submitted copies of the audit balance sheet, e-return, TDS and commission paid, TDS details, traveling and conveyance commission under the head of selling expenses. Further, in respect of additional under section 43B of the IT Act, the assessee made disclosure in Schedule 1 and N in point N in the account. This proceeded an ITIT to observe in para 17 that record region reopening assessment made no reference to any fresh tangible information which comes to notice of the after completion of the original proceeding under so and so. And reference was made to the decision of the convictor. Even regard the second question regarding 2-3 item, no fresh material enabled to. Having heard and counsel parties having carefully perused the impugned order, the court is satisfied the question framed to answer in affirmative in favor of the assay. Again, the department indeed that appeared to have been no fresh material to basis on which the AO was proceeded to reason to believe and pass the order. Now the question is Lordship has to decide whether it is precedent, whether the ratio has been laid down or not. As Milord, I understood Milord by my little knowledge. This is an order and no ratio has been decided. Therefore, Milord, I Lordship see the judgment of Supreme Court very recently passed. I am enclosing whether ratio decision and other things. No, for my satisfaction, for my satisfaction. So therefore, it is not a precedent even.
But sometimes it has some, it aids.
Correct.
The parties
Bow down.
or the court to
Bow down.
have some
But subject to, yes,
I'm not saying binding precedent.
yes, binding period, nor similar as ratio, whether the court says.
That we are not on.
Yes.
There is no point on this issue.
Now, your Lordship, that is the Supreme Court judgment I am close in my compilation. I don't want to place because Lordship has already come across so many cases. So now your Lordship see.
Now what is your point?
I am coming, Lord.
So far.
So far point is, my lord, subsequent, no, my lord. If I not place, my lord, I cannot place the Supreme Court judgment.
Okay, place it.
Otherwise, my lord, I may not place.
Place it.
Yes. Now you got see the latest judgment, page 19 of my yes, page 9.
SLP.
Yes. Taxman.
SLP can't decide it. This is
No. Let's say court said, yes, the assisting officer is permissible to issue notice when there is material which are not considered by this original proceeding. In the taxman,
this is also not a binding decision because this is not a judgment order in a particular case.
But it's Supreme Court order.
Supreme Court order. Supreme Court SLP rose every so many SLPs are getting dismissed. That doesn't mean that ratio there.
But the order which has been considered detailed order, I am having that order.
No, it's not a detailed order.
Lord, the Supreme Court says
this is short order. It is order, sir.
It is order. It is order.
But SLP stage
but it is add to my case that if it was not considered in the original assessment,
sir, if it is a judgment, then it has some the ratio has some importance. It is just order in a particular case. How can this?
But they aid to my case, Lord.
This might be for clarification purpose. Fine.
Yes. Now you Lord, but here same Lord.
How
No, here my Lord, the Honorable Court has held, my Lord, reopening assessment in considered liability could not said to be case of change of opinion. The binding effect is change opinion. Though there is Lord, suppose if there is a I'm just Lord, I'll give the judgment of the past by the Honorable Court. That High Court judgment or later on I'll submit. Now your Lordship see.
The same case.
Yes, arising out of the High Court order, I am coming with that order also. Because yes, High Court says, my Lord, there is change of opinion.
Sir, one thing, let me tell you. When against the High Court order, when we approach the Supreme Court, at the SLP stage, if it's something or some order is passed, that doesn't have a binding precedence. If a particular judgment is passed, entire, I mean, it has after going through everything, then it has something. And SLP in a particular facts and case, whether it is advocate,
no, it is not a fact of the case. Change the word is change opinion.
No.
Change opinion has not been accepted by the Honorable Supreme Court.
Okay.
Now you will also see. Yes, that other judgment also. My Lord, Javeri State Development Investment Corporation, my Lord, page 6, para 2 and 4, your Lordship kindly have a glance.
Yes. Yes.
Just a minute. Let's see para 2. After going through the detailed order passed by the High Court, we find that main issue which is involved in this case is not addressed by the High Court. A contention was taken by the Appellant Department to effect as seen the assessed return was accepted under 43(1) of the Income Tax Act. There is no question of change of opinion much as while accepting the return under the aforesaid provision, no opinions from harm. Therefore, on the basis the notice issued was valid. Now, let's issue para 4 of the same piece. We find that the pursuant notice issued under 43 of the income assessing officers computed income by passing an assessment order on merit and rejecting the contents of respondent that the aforesaid transaction did not amount to sale of assessment here in question. Again, the assessment or respondent preferred an appeal before the commission. Further appeal was preferred, so and so, so and so. So now, it is told that if not the assessment has not been considered, subsequently it has been considered, there is no change of opinion. Now, you will see subsequent next judgment passed by the Gujarat High Court, 2021. Page start from page 11.
Yes.
You will state where you see the paragraph 16, concluding paragraph. All these are similar to other issues. In view of para 16, para 10, last paragraph.
Yes.
Here is a TDS, your Lordship, see it here is a TDS and 140 AI has been considered. Now your Lordship see paragraph 10.
Yes.
In view of the above, it is quite clear the assessing has power to reopen if there is a tangible matter to believe there is an escape income from the assessment and when such materials are linked with the formation of the belief in the instance as stated, respondent affidavit the petitioner not deducted TDS as detailed annexure C6 to form 3CD, and therefore same was taken into consideration by the assessment while passing the order under Section 43 of the Act. When the said matter not considered at the time of original assessment or dated, the considered same may be respondent could not say to change opinion or review the earlier order. Therefore, my lord, in the present case, my lord, the same self issue of deduction has not been considered by the assessing of the time of 143 of the assessment order, and subsequent was found and order has been passed. Therefore, it is come within the purview of 147. Now, let's see next. My lord, Deputy Commissioner Income Tax is dated 1/9/2020. All are passed after the judgment passed by the Supreme Court. The page 17. The judgment we are relied upon by the tribunal. Kelvinator, correct. Page 17. Here also, my lord, same issues. If you lords have state, we have not burdened ourselves to read all these things. Page 20, page 29, paragraph 15.
Yes.
In a lengthy, huge paragraph, Lord. I'm just thus the objective satisfaction, Lord. 1, 2, 3, 10. Paragraph 15. 15. Page 29.
29.
Yes.
Yes.
But I'm not reading everything. It starts from below the 11th page. Thus, the object satisfaction would be sufficient. Thus, the object satisfaction would be sufficient for the purpose of allowing the assessing authority to proceed with the reopening proceeding once the material available and such material are not taken into consideration by the original assessing authority or any finding are given in the assessment order, which will be sufficient for the purpose of reopening assessment. And once such reopening is made based on a tangible material, then the assessee has to define his case by furnishing further particular expression document during the course of reopening proceeding. High Court cannot form opinion in respect of such finding to be made. Only endeavor of the High Court is to ensure that whether the conditions stipulated in purpose adopted the purpose of reopening assessment in considering the provisions of the Act and according to the directive of the Honorable Supreme Court in GK types. GK is something else, not given the regime and regime had to comply with.
Okay, that's all.
Next, my lord, page 31, the Karnataka High Court, dated 16/3/2022. Page 31.
Yes.
Here, my lord, the paragraph 11, running page 27. In this breakdown of the allegation made against so-and-so, indisputed fact that the assessment in case of Jindal Aluminum Limited, its was completed even before the company's survey proceeding, and the nature information shared by the petitioner account official, the court must find that the share hold bar for intimation for reassessment is satisfied. This court must conclude at this stage the AO subjective premise opinion, though is based on the record and made available during the assessment proceeding, is yes. And next one also same, not the commission income tax, not the paragraph is 39. Sorry, paragraph page 39. The finding is not paragraph not 5. This will be a lengthy paragraph on the similar issues, not what I said, that is the issue. Now, Milord, in concluding submission, we'll also see what was the order passed by the Honorable Court while admitting this. dated 21/11/20. 21/11/2020. Paragraph 4. Mr. Jali, learned counsel by the response state that issue or the revenue in this appeal completely covered in favor by the respondent by the judgment of Supreme Court in JE India Limited. So and so. The fact that JE India is so far as this case is concerned on the subject matter of the case. It is not a case that JE India, the issue is the factual issue has not been considered by the tribunal. Tribunal has straightway considered the culminator and passed the order that there is no tangible matter. Therefore, proceeding initiated by the revenue is not permissible. Okay. There is no superior fact of the case. So that is sum and substance of the case.
Yes, Mr. Jolly.
Malad, may I just
fully on that day?
No, may I, Malad, only point out I have put everything in my yes, I have put everything in my written submissions for make it to make it convenient for my lords. I have put everything in my written submissions. If my lords could just have my submissions with me for 2 minutes, I'll just take my lords through my submissions. That's it, my lords. If my lords will see, the tribunal, my lords, in this case, records 2 findings of fact which are not disturbed. Kindly see, my lords, those findings of fact in the appeal. My lords will have, my lords, in the appeal, page 14. May I, my lords, show in the appeal?
Yes.
Was actually beginning last para on 13.
Last time we have shown that.
Yes, yes, Malod. It records a finding of fact that there is no fresh material after the completion of assessment under, Malods will note the section 143.3. Because this is extremely significant. Because the judgments which my learned friend is cited and I have distinguished in my note already, my lords, are all.
This note of
but yes, if my lords, I have my written submissions. Yes, my lords will just have, my lords, page para 9 of my written note on page 3. Because on the last date, my learned friend had cited 4 judgments. Kindly just have, my lords, all these judgments for a minute.
Yes.
Because the first judgment my learned friend cited was of the Gujarat High Court in Peace Industrial.
Yes.
Now, Peace Industrial, if my lord will just have the first page of the judgment.
Yes.
Now, my lords, this, sorry, my lords, if my lords will have, I'm sorry. My lords will have, yes, I'm sorry, my lords, just have para 8, para 7 of this judgment where the reasons are recorded.
Which judgment?
My lords, Peace, PEASS, Peace Industrial. My learned friend had cited this on the last date. Was on the, he had given a copy.
Have you given the copy? Mr. Jolly, have you given the
Because
copy?
my learned friend had he had cited this to support his proposition.
Lordship, second copy, file on 29th, Lordship.
This copy.
Lordship.
Volume 1, volume 2, I am not having on
Lordship, Lordship.
So, Peace Industrial, my lords, have it.
Getting very that Peace Industrial. You give that judgment and paragraph. We'll see that.
I have, in fact, my lords, will just see my written submission. Just have 9 clause 1 of my written submissions on page 3 of the written submissions.
Yeah.
That para 9. As far as the case of Peace Industrial versus so and so is concerned, in this case, the AO received information from an external source, which was DGIT investigation Ahmedabad, after completion of the original assessment proceedings, that transaction executed by the assessee were bogus. In that case, it was held that tangible material was in the form of the report of the DGIT. In fact, para 12 of that judgment actually supports my case rather than my learned friend's case, because it says that tangible material is the report.
Okay.
Now, the second decision my learned friend cited were VP Industries.
VP Industries.
Yes. Because in that case, there was no assessment under 143.3, because that is an extremely critical fact. Because if there is no assessment under 143.3, there is no question of an opinion. But in my case, the original assessment is under 143.3, which the tribunal notes and then says there is no material after that. In fact, in that decision, the Honorable Madhya Pradesh High Court accepts the revenue submission that there is a distinction between 143.3 one assessment and a 143.3 assessment. Finally, my learned friend placed a lot of emphasis on Rajesh Javeri, the decision of the Supreme Court. Now, Malod, may only note two very important facts of that. Javeri was a decision of 23rd May 2007. Whereas, my lords, Kelvinator is a decision of 2010 after Javeri. Secondly, my lords, in Javeri's case, which my learned friend is citing, again, the Honorable Supreme Court clearly holds that this is a case of an original assessment under 143.1, not 143.3. Okay. Therefore, there is no question of an opinion. Okay. Because I have given the relevant paras of Javeri also. My lords will see para 9, clause 3. In fact, in that, what had happened, my lords, and it's noted in paras 5 and 6, the Gujarat High Court relied upon an earlier decision in Adani Exports to hold that there was change of opinion. The Honorable Supreme Court said Adani dealt with the case of 143.3, whereas Javeri deals with 143.1. Therefore, Adani will not apply and the principle will not apply here.
Okay.
Now, my lords, the final decision my learned friend cited again was of Kerala. It does not consider, my lords, a Kelvinator, okay. And it goes on to hold that Javeri has held that even when there is... Yes, my lords, now just come, my lords, to the reasons, because the law which has been settled by my lords and courts across the country is reasons cannot be improved or supplemented. Reasons must stand scrutiny on their own. For that, my lords, may I only show one decision of the Supreme Court in NDTV's case. That is, my lords, page 13 of my compilation of judgments, along with my written submissions. And the only relevant para, my lords, I'll just para 36 of that judgment on page 33, my lords, of my compilation. Lords, para 36, yes, New Delhi to NDTV, my lords. This is, my lords, starts in my compilation at page, yes, my lords. And my lords will straight away, yes. Just come, my lords, para 36, question number 3. On page 33 of this compilation.
Yes. Yes, question number 3.
Yes, my lords. It says it was heard before the court that in terms of proviso to section 147 so and so, limitation would be 16 years since assessee had derived income from a foreign entity. Then, my lords, the section is written. My lords, may kindly then have para 39.
Yes.
My lords, sorry, 38. In this regard, we may make reference to notice dated so and so. Notice is conspicuously silent with regard to second proviso. It does not rely upon the second proviso. Basically, it relies on provisions of 148. Reasons communicated to the assessee mention reason to believe that non-disclosure of acts by assessee. There is no case set up in the second proviso, either in the notice or even in the reasons supplied. It is only while rejecting the objections of the assessee, reference was made to so and so. Now, what does the Honorable Supreme Court hold? Just see, Malos, para 41.
Come to the point, sir.
Yes,
Why are
now
we-
Maloj will see the reasons. What
Stay
are
to
the
point.
reasons? Yes, what are the reasons?
Yes.
Just see Maloj the reasons which are extracted Maloj in the assessment order at Maloj in the appeal at page 19. Maloj have page 19 of the appeal.
Yes.
Because the assessment order starts from here.
Which?
Just have at the bottom of that page.
Yes.
Further verification of the assessment records. There is no fresh material. It is reappraisal of the assessment records. It is revealed that the assessee has incurred and debited expenditure towards so-and-so of so-and-so on which no tax has been deducted under section 191. Now see the second part of the reasons, Maloj, on the next page. It is even worse. Besides the above, on verification of assessment record, it has been revealed closing stock of the chrome ore was so-and-so in compliance to a query raised by the AO. So this issue was examined in the original assessment proceedings. It is a noting by the AO in the reasons himself that a query was raised, a reply was furnished.
Okay. That's all.
And now, Maloj, in that light, see the tribunal's order, there is no fault. And then I'll come to Kelvinator because Maloj, one para of Kelvinator has not been read to Maloj. It's very important. Now, Maloj, what? Yes, Maloj. Just may I show Kelvinator, Maloj? That's in my case law compilation, which Maloj were seeing. Maloj, it starts at page 5. And my lords will just see two things. Kelvinator also had another assessee before it, Aisha. My lords will just note it. Now, my lords will see in Kelvinator just two lines, my lords, on page 11. Sorry, page 8. My lords, I'm so sorry. Page 8, my lords have it. Page 8 of my compilation, para 6. Well, about 6 or 7 lines from the top on the right hand side, Malos will see a sentence starting with however one. However, one needs to give a schematic interpretation to the words reason to believe, failing which we are afraid section 147 would give arbitrary powers to the assessing officer to reopen the assessment on the basis of mere change of opinion, which cannot be per se reason to reopen. We must also keep in mind the conceptual difference between power to review and power to reassess. Maloj may not note that. The assessing officer has no power to review. He has power to reassess. And this is exactly what Maloj, the tribunal says. If you review material already on record, it is change of opinion. If you get fresh, tangible material, then it doesn't tantamount to a change of opinion.
Yes. That's all.
Maloj, last, I'm just showing Aisha, Maloj, for a minute, which is also set out in my, because Aisha was also approved by the Honorable Supreme Court in the same decisions. Now, just see one para in Aisha, which Maloj starts at 82 in my compilation. And the relevant Malords will have
yes.
At para 15 on page 87.
Yes.
Because in the Delhi High Court quotes the Punjab Haryana High Court in Hari Iron Trading and observes, in a division bench of Punjab and Haryana has observed that assessee has no control over the way an assessment order is drafted. It was observed generally issues which are accepted by the assessing officer do not find a mention in the assessment order, and only such points on which the assessee's explanations are rejected and additions are made, we agree. Applying the tests laid by the full bench as well as observation of Punjab and Haryana, we find if the entire material has been placed by the assessee before the AO at the time when the original assessment was made, the assessing officer has applied his mind.
Okay, that's all.
Yes, Maloj, just to show that everything was before the assessing officer, Malad, just my written submissions one for a minute and I'll close Malad with that.
I have gone through your written submission. Okay.
Grateful, Malad.
You have prepared well. Next.
Grateful, Malad. I'm so grateful, Malad.
Thank you. Matter closed. You want to give something?
No, Lord, I have.
That's all? Next.
Next, Lord.
Item 34.
34, Lord. This is also, Lord, revenue appeal.
Which prospects?
5 appeal are same grounds. Lord.
4.
Sorry, 4 appeal.
One written order.
Also, this your
Mr. Jali is appearing for the.
no,
Because here also I've given written
Yeah, the
submissions
question
and
has been,
compilation.
your lordship has shared us as formulated this question in the first, second day or third day.
Oh, okay. So, your father?
Mr. Jolly is appearing.
This Jolly is everywhere.
But one written argument and judgments are filed.
Where is it?
No, filed.
Give it. Yeah. This is similar. Yes. What is the issue involved here?
Yes, ma'am. Your lordship, 2 questions. One is, whether the tribunal is
Sir, when you're writing advocate P. Ramakrishna Patra, for whom? इसके लिए करते हो नहीं लिखोगे? You must write that for respondent, for petitioner.
ऊपर लिखी respondent लिखा है.
Good.
By respondent.
नहीं थी पूरा लिखिए ना. Counsel for the respondent. थोड़ा कम है. Clarify.
Like, by
Adopt some good practice from Delhi High Court.
हमें आगे ओडिशा रही थी सिक्योरिटी पिछो.
You have to adopt some good practice from other High Courts. You're always doing this where you were. Change that system. Yes.
My lord, here the lordship has to consider whether the resilience under the provision for diminution of the value of the Government of India fertilizer bond, whether the provision of the years has to be considered in the subsequent year, or the provision is not ascertained in the books of account, this provision has to be accepted as deduction under the, while calculating the profit and loss account of the petitioner. If your lordship see the tribunal, my lord, what is the grounds raised by the respondent is reflected in page 11, internal page 2 of the order of the tribunal, your lordship. See page 11, running page 11. Your lordship, see the first ITA 1.
11.
Your lordship, see ITA 1. One and 4 are same.
This is ITA 3.
ITA 1 and 4, lordship, ITA 1 and 4 is same issues.
Yeah.
And other additional issues not other.
Okay. So here you have
Here whether the provision has been considered by the
Annexure 1? You want to show the annexure 1?
Annexure 1, Annexure 1, next page, page 11, internal page 2. This is the assessing contents and has been reflected in the order.
Yes.
The relevant is 3.3 small a. The fact and circumstance of the case, the learning ITAT grossly erred and confirming the dissurance provision for diminution of the value of Government of India fertilizer bond amounting to made by the learner ignoring the merit of the case. Now you will also see the order of assessment. That is start from page 21, annexure 2. You will also for see page 22, paragraph 3. During the financial year 1910, relevant to assessment 1011, the company in its return of income had disclosed total income shown. During the financial 910, the assets are debited in the PL account amounting to so and so lakhs towards the provision of diminution of the Government of India bond. In the assessment 8-9, the assessor himself had to make the provision for diminution of government bonds in total, but In the assessment 910, no provision in respect which was made in the books of account. During the course of scrutiny, the assessment of the assessor has not submitted any evidence or provision to substantiate his explanation. Therefore, your lordship see whether the provision is to be accepted in the profit and loss account by deducting the same. Therefore, lordship, this is the core issue in this case. And second one is school expenses. I'll come later on because let us first complete this. Here, your lordship, see, in the act itself, my lord, there is no question of provision. Actually, whether you have to pay it, that has to deduct it. Here, my lord, there are some difficulties for part of the assessee. They cannot, my lord, actually has not made any actual dues for the bond problem. My lord. But my lord, your lordship, my lord, in the act, if exemption or deduction has been claimed, it's a strictly confined to the act. It cannot go beyond that. Therefore, my lord, my humble summons is provision cannot be accepted as a deduction. Therefore, lordship, see I have compilation given in the judgment. The Sajan Mills case is directly, my lord, covered in this case, and we have questioned that the Sajan Mill case was not considered by the Honorable Tribunal. Here, your lordship, the expenses as claimed by the petitioner in the Sajan Mills Limited were commission income tax MP Bhopal and others. In this case, you will also see para 12 of my compilation, para 31 and 32. And 36. It is under the scheme of gratuity. It is not exactly this case. It is the case of gratuity is to be provided by the government, whether in the specific act, whether it is permissible under the or not. In the provisioning, the gratuity came the deduction. And we will say better, my lord, 31 and 32 will see mark it, but I am placing, my lord, the 36 which is to shortcut the issues now. Here is a difficulty because here also difficulties, my lord, there are also difficulties. The aforesaid difficulty in accepting the contents or on behalf of the assessee were highlighted by the Calcutta High Court in case of People's Engineering Motor Was Private Limited Commission on Income Tax West Bengal. It was pointed out that the payment of gratuity was statutory liability created under the Payment of Gratuity Act. It could normally be said to have arisen for carrying on the business. However, for gratuity to be deductible under the Act must fulfill the condition laid down under Section 40A, Subclause 7. The deduction could not be allowed on general principle under any other act of the Act because subsection 1 of Section 40A makes it clear that the provision of this section shall have the effect not to stand anything to the contrary content in any provision of any other provision of the Act relating to computation of income and the head of profit and gain of the business and profession. In other words, it means that 40A would have effect not to stand anything contained in Section 30 to 39 of the Act. Therefore, my respectful submission is, if any difficulty in relating to any other act, the income tax is bound to accept the difficulty in other issues for claiming of deduction. So, but it's not been accepted, not been quantified, not been approved. It is only provision. So, therefore, the tribunal has error in law by accepting this contention of the assessment. Next, you will also see the judgment of Karamchand Thapar vs. Brothers versus Commission IT Central, page 15. Paragraph 12, page 19. Subsection 1 of loss or profit or gain suffer under any head of the year was held to be set off against the income. Profit or gain under any other head, and subsection 2, where the loss suffered in any business, profession or vocation could not be wholly set up under section 1. The loss not so set off had to be carried forward to the following year and set up against the profit and gain of the same business in the subsequent year. The tribunal in the High Court applied subsection 2 of section 24 in computing the taxable income of the company for the assessment of 50 to 51. But in so proceeding, in our judgment, we are in error. The business of dry ice factory was sold in October 1948. We'll assume that dry ice factory was a separate business of the company and is not a part of other business carried by the company, but the price which a business was sold and settled in 1949, until the price was settled, loss did not accrue or rise for the company. The loss was suffered in the account in 1949-50 and could allowed against the income that year under section 41. The assumption that the loss was suffered in the previous year, that is 1948-49, was junior judgment not warranted. Thus, the case was plainly governed by section 1 for section 24. The answer fourth and record must be discussed. Therefore, my lord, this, when it has been not ascertained, if it is ascertained some year, that has to take deduction has taken that year, not in other years. And the next, my lord, the Commission in Canada, Tamil Nadu versus Indian Overseas Bank, page 21. Here, my lord, the para is para 8. Here, the para is exchange quantification is there, my lord, para 8. On the facts, we have to find that amount claimed by the assessee represented the deduction in the notional value of the outstanding foreign exchange contract, which were yet to be settled, and therefore it was only a notional loss that is claimed by the assessee. If the outstanding contract were determined by the parties as per term of the contract by either of the parties, it will stand different footing. Then the loss or profit accrued arising on such foreign exchange contract will come to a computation of profit of that year. But where the contract has not yet been settled, where the contract actually resulted in a profit and loss account as loss cannot known during the assessment year, we do not see how the assessee would claim this said amount as a loss actual arising during the accounting year. Therefore, my lord, my whole and the submission so far as this question is concerned, my lord, this issue was not arisen that year. Even assuming, Lord, here some difficulties, there are some difficulty admitted, Lord, there is a difficulty so far as the respondent company is concerned. But we have to go by the act itself, and the computation has to calculated and deduction has to made in accordance with the law. And the next question here is ITA, my lord, kindly see ITA 3. 3 and 42 are same question, but 43, your lordship, kindly see the question. Here the question is, case 8, whether in the fact and circum the case and the law, the learned time right in deleting the addition made rupees so made under school expenses, treating the expense as a business expenditure. Now, lordship, see what is the business of the company. It is a fertilizer company.
So what is the business expenditure? School.
School. That is not the how not the claim the school expenses, because it is not in direct. If not the person, the staff of the company, exclusive the sons and daughters are studying there. Whatever expenses company when welfare scheme may be adopted, that amount has to be deducted. No issue, Lord. But here he has well given amount as a donation or something like that. I don't know. That amount has
could have been there. See your CSR, something like that. It could have.
But welfare scheme also they could have. But here he has not quantified what is the how many students are studying there, who are the the father and mother, the employee or the
whatever grant they give.
Yes.
So that is also business expenditure.
Yes, that cannot be treated as a business expenditure. Therefore, 37 is not permissible. If your lordship, I rely on the judgment of the Voltas Limited.
Yes.
Lordship, see.
What does it say?
Here, let's say here, Millard, the payment of donation to Tata Refugee Relief Project done donation is not disallowed in view of the section 37(1).
It is disallowed.
It is disallowed by the Bombay High Court. So therefore, Millard, if it has not a direct link with the business, there is not major at it, should not be allowed. That is the leave it to lordship.
Yes, Mr. Jolly.
My lords, on the first question, my lords, again, what I've done for my lord's convenience is filed a written submission along with the case laws. My lords, on the first question, may I first explain what is the transaction? My lords, the government of India was bound to give me a subsidy it could not give me the subsidy in cash. So what it gave me were Government of India fertilizer bonds. So Malaj, if the Government of India had given me the subsidy, it would have formed part of my income direct, no problem. Government of India couldn't give me the subsidy. Instead, they gave me bonds. Now, what happens is, Malaj, at the end of the financial year, there was a diminution in the value of the bonds. Therefore, if I were to receive 100 rupees, now the value of bonds became 80. I had recognized the entire 100 as income in the first place because the value of the bonds was 100.
The diminution value you are trying to take.
I claim that as an expense. Now, Malaj, this exact same issue arose for consideration before the Honorable Delhi High Court, identical case. And therefore, Malaj, I'm just showing that DCM Shriram, Malaj, it's in my compilation. At page 3, Malaj will just have that.
Okay. DCM Shriram.
Yes, Malaj.
Page
3. Page 3, Malaj will see page 4 is where the decision relevant paras 4 and 5. Because it says
where did you decide? Which paragraph?
Malaj, para 5 itself. Because it says para 4, the first issue that rises for consideration is whether assessee could have claimed loss for diminution in value of fertilizer bonds against sale of fertilizer. It was exactly same issue here. The assessment order is
claiming a revenue loss.
Yes. And Malaj, I'll come to the fact whether it's a provision or actual loss. I'll explain that principle also. Malaj, what happens is at the end of the financial year, there is a diminution in value. What I do is for accounting purposes, which is mandated by the accounting standards, I treat the bonds.
Standard does it mandate?
Yes, Malaj. Just give me that's noted in the assessment order itself. I'll just show from that.
Yes, please go ahead.
I'm so sorry. I'll just show. We'll just have the tribunal's order for a minute. And Malaj will just come to Malaj's page 13, because where the tribunal reproduces its own earlier order. Malaj have ITA 1 if I'm. Yes, Malaj will just see. And Malaj, in the reproduced part, just see para 21. Malaj. We have heard rival contentions and perused material on record. Assessee has claimed loss in diminution of government fertilizer bond. The learned AR submitted these bonds were issued by Government of India in lieu of payment to be received by the assessee as they are disclosed in balance sheet.
The question is basically it is allowable loss or not. That's all. Revenue loss they are saying whether it is to be allowed or not. That's all.
Yeah. Yes. Malaj, that's what I'm showing. Malaj, what is already
reproduced. You are saying that is allowed. Then any other judgment you have.
Yes, Malaj, DCM Shriram considers this.
Any Supreme Court judgment you have.
Malaj, this, in fact, I checked, DCM Shriram department has accepted the decision and not gone to the Supreme Court.
Oh.
I checked with the counsel for DCM Shriram also. They've confirmed department has not gone to Supreme Court. And they've accepted decision. And my learned friend cited Sajjan Mills.
Forget this decision and all that. So what is the, I mean, you are talking about the accounting standard.
Yes, that's exactly what I was showing, Malaj. If Malaj will just see the reproduced part on page 4.
Anything
yes.
to the accounting standard?
Yes, Malaj, it is. That's what I was showing, Malaj.
Where is that?
Just see page 14, Malaj,
I'm there.
of the appeal. Just see the third line from the top, Malaj, in the italicized portion. It is also pertinent to note the assessee was entitled to receive fertilizer subsidy in cash. But due to shortage of funds, which the Government of India as an alternate was created, an assessee company was compelled to receive fertilizer bonds in lieu of cash. In this situation, we hold assessee company rightly showed these bonds as other current assets under the head current assets, loans and advances. In the case of Patnaik and Company, the Apex Court explicitly held where the investments were made under commercial expediency for the purpose of carrying on business, then the losses suffered on sale of such investment must be regarded as revenue loss because the investment did not bring into an asset of so and so nature. Well, this is exactly what I'm saying, that this is my same treatment.
Okay.
And on this, yes, the second question, Manoj, on the school expenses. Manoj, there are at least 6 decisions of different high courts on this proposition. And I put that.
Listen first, explain how school
I'll
expenditure is in business.
I am so great. Manoj, at first blush, it does not, it sounds very odd. What happens, Manoj, these factories which my
which provision does, I mean, under which provision there must be
37, Manoj, it will be 37.
Huh?
37.
37.
Yes. I'll explain how, Manoj. Manoj will just have 37.
Yes.
Will have, it says any expenditure not being in the nature of 30 to 36 and not being in the nature of capital expenditure or personal expenses laid out or expended wholly and exclusively for the purposes of business or profession shall be allowed in computing the income.
What is the purpose of business here, sir?
Yes, that's exactly what I'm explaining.
Yeah.
You know, I have factories in remote areas where I have to attract people to come and work.
Where is your factory in the remote area?
Yes, Maras. Let me just show that. That is recorded again in the assessment.
Is it
Maras, just give. Maras, we'll just see the assessment order.
Beautiful township you might have visited also. Where is the remote area?
Maras, I'm just showing from the assessment order, Maras.
No, just explain simply one, just as a layman, just how you explain
yes,
it.
Malas, yes, that's what exactly. Malas, what happened?
Anything about taxation law? How will you explain the school expenditure is a business expenditure? I'll
explain, Malas. In fact, Malas,
don't go.
I could explain it in my words. I could show it directly from what Malas, the Kerala High Court has held.
No, Kerala High Court, you explain me first how it is.
Yes, Malas, I'll explain. Malas, the most important aspect for any factory to run are its employees.
Fine.
That is the most important. For me to run a factory, my employees must be happy and they must run.
Disputing that.
So, Maloj, therefore, what is allowed as deduction is employee benefit expenses. Now, one of the ways of giving benefit to the employees is giving them cash and tell them you can send your children to best schools. The other is I pay donation to a school which then accommodates the children of my employees. Malaj, I could directly give them cash, but then there is no
business expenses.
Yes, Malaj, that's exactly, Malaj, this question has attended to
I'm not convinced how it is business expenditure.
Malaj, it is
you could have called it as some welfare expenditure, something else, CSR, whatever.
Yes, Malaj, that is also allowed. Malaj, when we say business expenditure, it must be for the purposes of business, not to earn profit. Malaj, it is not. Malaj, it is not. It is not only to earn profits. In fact, my lords, there are decisions replete that even to maintain a park, there are decisions to maintain a park, to run a school, exactly on these facts have been held to be
business expenditure, sir.
Balas, because it directly benefits my employees.
Directly benefits the employees.
Balas, in that sense, what has happened is how does payment of a hotel fee where the director says, how does it affect my business? But that is also allowed. If my director is traveling, it doesn't affect my business directly, but that expense is allowed
Traveling is
because
different.
the
Actual
because
traveling
the,
is different. But
Malas, in that, Malas, because the expression in the act is not expenditure incurred to earn profits. Malas, it is the expression under the act is not expenditure incurred to earn profits.
Which judgment you are showing?
Malas, just see, Malas, in the notes, Malas will see first the Kerala High Court one, which is the first on this point, which is Malas at Radhakrishnan, page 25, Malas.
Page 25.
Yes, Malas.
Okay.
Malas, that's the first decision, Malas.
What is the paragraph?
Malas, just see the question of law which is set out on page 26. Question number 3, para 2. Whether on the facts and circumstances should not the tribunal have equated contribution to FACT with contribution to government school and considered and decided the agra? Well, this is exactly what was the fact there.
Where is the answer of this?
Yes, Malaj. Just see, Malaj. Malaj, just see page 27. The second last para.
Result for that from that?
Well, the expenditure, well, after section 37 is reproduced.
Okay.
The expenditure met
fully
only
and exclusively
for the welfare of the employees of the SSC, not covered in section so and so, and not is allowable under 37. In the present case, expenditure is towards contribution share of expenditure in running the FACT school, wherein children of the employee were studying. An extra so and so would make it clear expenditure was towards proportionate share of so and so. Now, Malas, this is then again the Kerala High Court follows it in Travancore, which is at page 18. Yes, page 18, my lords. Again, the same question of law, my lords, will see question number 3 there also.
Where is the answer of this?
Yes, my lords. Answer is in para 10. My lords, it's almost identical in that sense. Because Kerala High Court took a consistent view, my lord. There is then, my lords, a decision of the Madras High Court, which is, my lords, in this same compilation at page 15. There, my lords, the expenditure was paid to the Panchayat for upgrading the school. And the Honorable High Court, my lords, will first see the question on which is set out on page 16 at the top. And Malod's will see, in fact, the precise question which Malod's put to me was put by the Honorable Court to itself on page 16, last para.
Yes.
May I, Malod's, read about 8 lines from the bottom?
Yes.
The only question that is to be decided, Malod's, have that?
Yes.
Is whether the expenditure was incurred for the purposes of business of the SSC. The finding of the appellate tribunal is by making the contribution to the Panchayat for upgrading the elementary school, the SSC was assured by the management that it would give preference in matter of admission to the children of the employees in the said school. The tribunal placed reliance on the order dated from the president of the building and Parents Teachers Association. It is well settled if an expenditure of sum of money was expended for education of the children of the employees, it should be regarded as staff welfare expenditure, particularly in view of the fact in those days it is very difficult to get admission in educational institution. Employees are given satisfaction by donation, so and so, Malad. So therefore, this was another case. And Malad, the Rajasthan High Court has also taken the same view. Yes, Malad.
That's all.
Two lines. Blood in 37 is placed not. 37 explanation 2 kindly have a glance. It's clearly divar. The act itself divar. Explanation 2. May I please?
Yes.
For removal of doubt, it is declared that for purpose of section 1, any expense incurred by the assessee on activity relating to corporate society, corporate social responsibility, referred in section 35 of the Company Act, shall not dip to an expenditure income of the assessee for the purpose of business or profession. So clearly bar.
This was inserted from 2015, will not apply to the assessment years in question.
This is
This
assessment.
Lord, this is
Yes.
2 assessment years there, Lord. One is
Because I'll tell where the assessment years in which my lords are concerned with at 10, 11.
13, 14, 14, 15, and 12, 13.
No, it is CSR. No. This is CSR.
and now your lordship see
This is CSR.
So these are CSR expenditure. We have not claimed this as CSR. My learned friend is now adding a new fact which the AO did not say, which the commissioner didn't say, which the tribunal did not say.
This is CSR.
And anyways, this is after
and
2015,
now
not
your
prior
lordship
to that.
see the order passed by Delhi High Court.
Which one?
This place, Lord, by the Mr. Jolly's place, my
Same.
yes, Lord, the first one. It is a ITM, Lord. Your lordship see what is the order, phase 3 of the compilation given by the respondent counsel. It is ITA.
DCM, no?
Yes. It is a ITM, Lord. No question is formulated. And lordship see how can it be said, Lord, that is a relating to.
Anyway,
But therefore, my lord, so far this decision is concerned, it is not a judgment. No question has been formulated. It has not been answered. Therefore, it cannot be treated as an order passed under 260A of the Income Tax Act. It is only, my lord, the finding fact, my lord, the last word, page 5. Why it has been added? It has been averred by the assessee and not contradicted by the revenue that no interest expense has been incurred by earning exempt income. Only finding is that the revenue has not contributed the issue. If it is so, my lord, I may humble servant not be. My lord, real.
thank you.
Grateful, Malad. I'm so grateful.
My lord, the next one,
35
35 I read time, my lord, I am not prepared this case.
Well, it's only last time everything has been hard. That
No, lordship has not formulated
No, no,
question.
no.
Nothing has
It's
been hard.
not required.
No, for you it is not required. For me it is required. My appeal. It is not your appeal, sir.
That is an NPV issue.
Yes,
NPV.
it is my appeal, sir.
Well, that's
It is
what
not
I
your
propose. Yes.
Yes, your lordship frame the question.
Now, Lordship may kindly see. Lordship may frame the question later on. What I propose
Later
is
on.
like this. Just a minute. Mr. Satapathy, why you are so much anxious?
You are anxious in my appeal. You are standing in arguing the case. Then
You are,
you are anxious, more anxious than me.
Is it totally no question of law, far less substantial. question of law.
Let it be framed and we will see that
Yes,
whether
that
there
is
is
what
substantial or not.
that is what the 260 says, my lord. And Supreme Court also said that.
Lordship may, that question has not been properly framed.
The 260 clearly say Honorable Court has to admit the formulated question of
Yes,
law.
and
We are just
also
formulate. Question law has to
subsection
admit by the court.
Subsection 5 of 268.
Yes.
Subsection 5 of section 260 also says empowers this court to formulate any question which arises
Out of the order.
from the order of the tribunal. And the code of civil procedure will apply.
Whether the capital outlay.
No. Whether NPV, Lordship may kindly see. Yes, I'm sorry.
Whether the tribunal is justified in deleting the addition of the 13 crore 71,584 made an account of NPV and towards acquisition of forest land and compensating afforestation.
No, that is not acquisition of forest land, my lord. That is for the purpose of mining operation. I have to pay as a
That NPV I know, sir.
yes, acquisition of land. that will be a capital
Sir, hearing ବେଳେ ହବନି?
अरे रुआ मा hearing ବେଳେ
ଆରେ ଆପଣ ରୁହନ୍ତୁ ରୁହ ମ।
ଛାଡ NPV ଲେଖାଲି
ରୁହ ମ।
NPV
We are confusing the
compensatory appreciation karo.
yes
Even
yes.
though such अपन टिके ରହିଲେ ସିନା sir.
Sir,
Let me
sorry
complete
sir.
na.
Yes yes.
Appreciation even though such eligible for direction is a revenue. Good question to man now.
For grant of forest
Your
clearance.
Lordship, only may I submit, not 37 one has to be considered, my lord.
ସେଇଟା ହେଲାନି ସେଇଟା ହେଲା ସେଇଟା ହେଲା
37 because that is the important is not. Reduction has to claim under this. Yes, second. Much obliged.
you have no case.
Place the matter for final hearing on 9th November.
Much obliged for present hearing.
Question institution. Question is not you or anybody else. No, just tell your higher official who is in the bank, the regional manager, or whoever there in the Bhubaneswar circle. They should, whenever something, the notice is sent from this court, they should respond immediately. So many lawyers are there, just otherwise you can designate some person whom we can, in all item we can call him, then he can distribute the cases. This is how it can be done also. Do something. This is not the way we just will come after 4 years merrily.
My lords, may I mention on the virtual lordships?
In this case, my lord, the petitioner prays for the refund of the excess deposited amount.
So why this excess deposit are not being refunded, sir? Not the OTS. Is it OTS?
OTS. Okay.
What is the refund you are seeing?
2000.
What kind of refund you are seeing?
Sir, they are claiming that they have made some payment before OTS in 2010.
How can that be payment? That be adjusted only. OTS ରେ ଦେବେ ପଇସା ଆଉ ଫେରା ହବ
ସେଟା adjust କରାହେଇନି।
ଆରେ କିଛି adjustment କରାହବ ଖାଲି କେବଳ adjustment. They can't be refunded.
My lord, ସେଟା
loan ହିଁ ଭାଇ whatever amount is there ସ୍ୱାହା ସେଠି ଯିବ ଆଉ ସେଇଥିରେ ଆପଣ OTS ଦେଇଥିଲି ପଇସା ଦେଇଥିଲି OTS adjust କେବଳ adjust ହବ ଆଉ କିଛି ହବନି।
ସେଟା କୋଉଥିରେ adjust ତ ହେଇନି।
କୋଉଥିରେ ଲୋନ ରେ ତ ହବ କୋଉଥିରେ ଲୋନ amount କାଟି ଦେବେ ସେମାନେ ଲୋନ ରେ ଯୋଉ ଆପଣ ଯୋଉ ପେମେଣ୍ଟ ଯୋଉ କରିବାର ଅଛି ସେଇଥିରୁ କାଟିବେ। What is wrong in that? That is only the thing. That can't be.
My lords, may I mention a matter?
Can't be, sir.
For OTS, my lord, in 2010, this honorable.
Can be, sir. OTS is the one-time settlement. One time you can't have it again. Some installment kind of thing there. So if you ask for installment, they'll say no. Naturally, because the bank has to sacrifice a lot of money for the OTS, along the OTS. And if they consider OTS, you should take advantage of. Suppose you fail to take advantage, you are gone. Who can help you? ଆପଣଙ୍କୁ ପାଣି ପାଖ ସେଟା ନେଇକି ଯିବେ ଆପଣ ପାଣି ପିଇ ବି ଦେବେ କି ପୁରେଇକିରି ସେଟା ବି କରିବେନି ଆପଣ ଆପଣ ଚାନ୍ସ ଦିଆଗଲା OTS ପାଇଁ ସେମାନେ କିଛି ରାଜି ହେଲେ ଦେବା କଥା ଆପଣ ନ ଦେଲେ ଯାଆନ୍ତୁ।
OTS ପୂର୍ବରୁ ଯୋଉଟା ଦିଆ ହେଇଥିଲା ମାନେ
OTS କରିବା ଦିଆ ହୁଏନି OTS ପୂର୍ବରୁ କଣ ଦୟା କରିଦେଲେ ବ୍ୟାଙ୍କରୁ ଲୋନ ନେଇଦେଲେ ଲୋନ ପାଇଁ ପଇସା ଦେଲେ OTS ପୂର୍ବରୁ କଣ ପାଇଁ ଦିଆଯିବ କିଛି ହେବନି ଶୁଣନ୍ତୁ nothing your prayer is not allowed.
Transaction କଣ ହେଇଛି ଟିକେ ଦେଖ
ଏଟା ବ୍ୟାଙ୍କ ସାଙ୍ଗେ କଥାବାର୍ତ୍ତା କଣ
RTI ରେ ମାଗିଲେନି ସେ ଦଉନା
RTI କା ମାଗିବେ ବ୍ରାଞ୍ଚ ମ୍ୟାନେଜର ମାଗିଲେ ଦେଇଦେବେ କଣ ପାଇଁ RTI ମାଗିବ ସବୁଥି RTI ବ୍ୟାଙ୍କ ବାଲା କଣ କାହାର ଡେଟ୍ ଅଫ ବାର୍ଥ ବି RTI ମାଗନ୍ତି ଲୋକ ଡେଟ୍ ଅଫ ବାର୍ଥ ତମେ RTI ରେ କଣ ମାଗିବ?
Lordships, may I mention on the virtual mode, lordships?
You have approached proposed amendment to insert the following. Issue direction to opposite party to refund. The prayer of the petitioner to issue direction before this court to issue direction to opposite party to refund the total amount of 6 lakh along with the interest thereon, out of which 5 lakh which was deposited by the petitioner on 28/1/2010 and 1 lakh deposited by the mother of the petitioner on 24/9/2007, which was not taken into loan account, number so and so. So loan account is the nele tale.
Sir, এটা sir DPA বহুত দিন ধরে এইগুলো রাইট অফ হয়ে যাইতো এখন রাইট অফ দেওয়ার পর আপনাদের অ্যাক্রুড ইন্টারেস্ট আপনার অ্যাকাউন্ট টু ডাইরেক্ট অ্যাপ্লাই করবে যেটা স্যার ওকেস অ্যাপ্লাই করোগে অ্যাক্রুড ইন্টারেস্ট ক্যালকুলেশন করে তারপর অ্যামাউন্ট করে দেয় 2010 में जब कोर्ट ऑर्डर डायरेक्शन निकला कोर्ट से परिचालन संपूर्ण देगा सेल में क्लोज है 2010 में देवा पर 2016 को
the petitioner files the present petition starting that files the present petition claiming the excess deposited amount of ₹5 lakh along with the interest thereon which was deposited by the petitioner on 28/1/2010 in the shape of accounts pay order of Syndicate Bank Puri branch which was not taken into the loan account number 1091332. So land council petitioner for the submit that since he has deposited that amount prior to the OTS, the bank should have refunded the money back to the petitioner since the OTS is not considered. Since the OTS is not considered. Since the petitioner is a loaning and he has not paid the
OTS has been considered and that is delay.
Sorry, OTS is
Considered in 2017, which was 2010. He pay.
What delay then?
Then 2010 no thila last date thila to pay the settle
That
amount.
he couldn't pay.
He don't pay in
That's
2017.
why the OTS was available for the petitioner. He could not avail the benefit of OTS because of paucity of funds. Land council, the prayer for the petitioner cannot be entertained since the petitioner is a loanee and there is and take a loan from the bank. And the bank has every right to adjust the amount. Hence, no question of the fault. Disposal.
My name is.
Hello, transaction details.
The branch manager, what is your name, sir? Abhijit Kumar Sarpati.
Chief Manager.
The chief manager. And he has assured the petitioner to give all the details of the transaction, whatever required of the petition. He has to approach, he will approach before the bank within 1 week from today, and he shall part with those transaction details. Next.
Item 18.
18.
Appeal against the order on.
Sir, ये कितना समय लगेगा कितने?
Idea like you.
आज ही कौन समय था? Just रखो अलग.
First item that is complicated
तो
because
काम करो. Let it be heard on 10th कर रहा. 10th अच्छी किस? 11th 11th कर रहा था. 11th. Let's go.
Along with ARBA 5 of 2023, that has been it was listed.
সেটা আরথর থিলা কেমতি ডিলিস্ট হই যাইছি ইয়া সাঙ্গরে আছে
Let it be listed along with ARBA
5 of 2023.
5 of
23 man.
Next.
Item number 1.
1.
Lordships, may I mention matter, Lordship, in virtual mode, Lordships?
The petitioner filed this application for a direction from the Hon'Ble Court to the opposite party to disburse the outstanding amount towards maintenance and management of Sodhar Gruha from October 21 to March 22, that is period of 6 months, and Ujjwala Home from July 2022 to March 2023.
First time coming.
First time coming.
The petitioner present petition.
May I submit? Petitioner approach the collector, who is the disbursing authority. Let the collector decide that matter. It is pending.
Let him, the collector is the authority, then let him decide.
Yes, approach the authority at Annex 7.
Annex 7.
Let notice be. That notice we should wait here by collector किसी करेगा. Whatever, let it be solved here. If present petition, the present petition challenges the election of the parties in not releasing the balance of amount towards management maintenance inmates of Sodhar from October 2021 to March 2022, 6 months, and the management maintenance inmates of Sodhar from July 22 to March 2023, 9 months, total amount of 42,78,000. in favor of the petitioner's NGO to the petitioner for the same. Petitioner has also made a recommendation to the collector. Which district? Kalahandi. Seeking disbursement of the outstanding amount. However, they said collector has not yet taken any action. They said recommendation. So view the matter that no should notice be issued to the number
1 to 4.
1 to 4. And the state version is the website notice for all the parties. Give copy. This is the matter on 17. 17.
Item 2.
April next week, item 2.
Next week. 12 us. Next.
Item 3.
Contempt. Non-present.
And in this case, it has been complied with.
Complied with?
My lord. Entire amount has been transferred.
This transfer this state has submitted that since the order of this court has already been complied with.
And I got the instruction I've handed.
He has handed over the instruction from the office of the Tahsildar Mahanga. In such way the matter, the content disposal. Next 4.
Item 4.
Yes, Lombard.
My lord, the first item has been filed by Mr. Nath for the claimant, who is the respondent opposite party in the second case. The
You
order
are
of
for
the
the-
ombudsman is under challenge.
You are for the
I am for the insurance company.
insurance company.
So
What is the
here he is asking for, he has come to the ombudsman after 5 years. That day I was.
So the time frame.
Time and other aspects are there. Aji to bodhe samay habani. So my lord.
ଆଉ ଗୋଟେ କେସରେ ମୁଁ ଗୋଟେ IRDA କୁ ନୋଟିସ କରିଛି ସେଥିରେ IRDA କହିବ ଯେ immediately ମାନେ କେତେ ଦିନ 1 day 2 day 5 day 1 month 2 month ମୋ ହିସାବରେ 3 ମାସ ମିନିମମ୍ ଦେବା କଥା immediately ମାନେ 3 ମାସ ରହିବା କଥା that let him come and see and immediately ମାନେ ଜଣେ ଲୋକ ଜଣେ ମରି ଯାଇଥିବ ତା ଘର ସାଙ୍ଗେ ସାଙ୍ଗେ ଘର ତାର ସେ ସବୁ ସେରିମନି କରିବ କି ବସିକି ଆସିକି ଇନ୍ସ୍ୟୁରାନ୍ସ କମ୍ପାନୀ ପଛରେ ଦୌଡ଼ିବ minimum
additional affidavit regarding that, Your Lordship. There's a vesting order.
give a copy to the government.
Lordship, I'll today I'll give it.
Then
the course of the day I'll.
Just copy. They'll go through it.
Okay.
Let's 11. 11.
11. My lord.
Highlight it in the counter.
My lord.
Next.
Item 6.
6 and 7 hour.
6.
My lord. The loan took loan of to the worth of 20 lakhs. It paid. Then he take an additional for COVID. It is now 2 lakhs odd. He offered one time settlement for the principal amount exempting the interest. 2,15,000 is the principal is 1,15,000.
ଓଡ଼ିଶା ଲୋକାଲ ସବୁ ପୁରା ଗୁଜରାଟରୁ ଡାକିବି ସେ ଲୋକକୁ ମୋର ଇଜ୍ଜତ ନିଲାମ ଆଉ ଚେୟାରମ୍ୟାନ କୁ ପଢେଇଲେ କଣ ଭାବିବେ କଣ ପାଗଳ ଅଛି ଓଡିଶା
ଚେୟାରମ୍ୟାନ
ପଢୁଛି ବୋଲି
ପକ୍ଷ
କହିବେ।
କରେ ଚେୟାରମ୍ୟାନ କଣ ପକ୍ଷ ହୁଅନ୍ତି?
ଆଉ କରୁଛନ୍ତି ତ ଆପଣ ନା ପକ୍ଷ ହୁଅନ୍ତି କଣ ସବୁ ପ୍ରାୟ ଦେଖ
ଚେୟାରମ୍ୟାନଙ୍କର କିଛି ଏ ଗଣ୍ଡଗୋଳରେ ଚେୟାରମ୍ୟାନଙ୍କର କିଛି
ଚେୟାରମ୍ୟାନ କରୁଛନ୍ତି ବୋଲି ତ କହୁଛି
ସାର୍
ହଁ
abandoned person.
local
Aye.
Land transfer the petition to impede the local branch manager of Aditya Finance ऐसा branch manager पुणे लिखिले गुजरात लिखिले branch manager local थियो ना local branch manager with Odisha address
ମୁଁ ବୁଝିକି ଦେଇଦେବି ଓଡିଶା address.
हमने चेंज करो दो plan and implement application accordingly list matter 11 आसु
आगे
Item 7.
न करिवे लोकल नले केंदी डाकिबी केंदी मु ए गुजरात से केबे आसीबेनी अननेसरी खाली पार्टी कर नोटिस छाड़ दवा कथा खाली देखिबे ना न देखिबे केंदी जूनियर कर दवा कि कर दवा आपण पळे बिचुप जूनियर का भालू को कुबीर कर दला आपण मान जिबे हां आपण देखिबे पड़िबो before it is filed senior must check it never rely on junior because they are junior that's why सीनियर माने चेक करिया जूनियर दोष देला हबनी जूनियर भूल होला जूनियर दोष नहीं सीनियर दोष हां सब सीनियर मन कहू जूनियर माने मेंचे रखले कोन हबो ताकू दिन तो ट्रेनिंग देबेनी नेक्स्ट
606 sir first item re contempt we have paid the amount last time Mr. Patnaik was directed to take instruction from his
कोडा कोडा
ये जो item 7
Two items are there.
606 contempt 606
हां हां
we had filed also the proof of payment we will
We are
pay
in
it
the
to the oil
process of
company oil and
payment.
company in turn will disburse to him
oh that this
so lordship directed Mr.
gas
gas cylinder
Patnaik is appearing.
Patnaik
We
is
are
there
in the
in
process
CR.
of payment, making the payment. I thought we are in touch with the petitioner also.
पहला ले टिकट स्लैंटिंग न करो सुनिलो कमे कहले सुनिलो कमे
शुभ न्यूज
है टाइम लागबो
We are in the process of making the payment, my lord.
first item
Yes, Sangeeta and Jena, we are in the process of making payment.
so we are making payment
We
By
are
what
in
time
the process
will pay?
within 10 days.
within 10 days lane कांसी पता year पता
oil
Srinivas Patnaik.
नहीं नहीं
BPCL.
नाम पचाली
BPCL
for the
BPCL, Bharat Petroleum Corporation.
BPCL submit that he will
pay the amount within 10 days
within 10 days from today
Second
Second item of infrastructure.
No, already paid.
paid
Second already paid.
Conduct season already order of the school
let it be disposed of your lordship first item
First dispose of
ତମେ ନ ପାଇଲେ ଆସିବ ଆଉ ଥରେ
ଆଉ ଥରେ ଆସିବ ସେ ଥିଲେ ପୁଣି ଆଉ କୋଉଥରେ ଆସିବି
10 दिन ପରେ କଣ ହେଲା ଥାଉ
ଆମ sir as far as we are concerned we have paid
ଆପଣ ଏଭରେଜ ଫି ମିଳୁଛି ନା
ନାହିଁ sir
ମିଳୁନି
ନାହିଁ
ଆପଣ ଆନ୍ସର କେମିତି ଆପଣ
अरे सीनियर बड़ भाई सी
नेक्स्ट
Item 8.
disposable your lordship can give him liberty also dispose or give him liberty
ଗୋଟେ ଲୋକଟେ ହାତ ଦେଖୁଥିଲା
अरे बड़ भाई के धर
ଛୋଟ
परिबे
ଛୋଟ କଥା ହାତ ଦେଖୁଥିଲା ମୋ ଗୋଟେ ଭେରି କ୍ଲୋଜ ଫ୍ରେଣ୍ଡ ହାତ ଦେଖେଇଦେଲା ହେଲା କଣ ହବ ମୋ ଫ୍ୟୁଚର ଦେଖଲା ସେ ଦେଖ ଫ୍ୟୁଚର ଦେଖଲା ଏ ଗଲା କିଛି ଲାଗିଲା କିଛି ମିଛ ଲାଗିଲା ଗାଡି ଷ୍ଟାର୍ଟ କଲା ଏ ପଇସା ଦେ ତୁ ଜାଣିନଥିଲୁ ମୁଁ ପଇସା ଦେବା କି ନାହିଁ କି ହାତ ଦେଖୁଛି ସେମିତିଆ କଥା
ସେ ଯୋଉ ସିନେମା
ଆପଣ କ୍ଲାଏଣ୍ଟ ର ପଇସା କଲେକ୍ଟ କରିପାରୁନାହାନ୍ତି ଆପଣ କେମିତି ଉକିଲ that is also an art that is a concept called creative billing
certain things are not there
purchase both creative billing next
Item 8.
May I please alert?
9
I'm in custody since 24 June 2020.
କଣ କରିଥିଲେ
Ganjai re more than 3 years 3 months.
ଗଞ୍ଜେଇ ବାଲା ସବୁ ତ
Again 3 years 3 months
All
ରହିଲେଣି
these are-
again 3 months 3 years 3 year 3 months ରହିଲେଣି ମୁଁ
କେତେ
again
କେତେ କ୍ୱାଣ୍ଟିଟି
quantity 330 kilo local person
ଯାଉ
and
क्रिमिनल एंटीसीडेंट थिला आगुरु
କେତେଟା
गोटे थिला ए एनडीपीएस
गंजेरे
एनडीपीएस
no सेटा below commercial quality I have also filed in complaints below commercial 10 kilo
ଯାଉ।
thila and
तीन
lordship
वर्ष-
mainly last occasion colored the
वर्ष
adjourn the
तीन वर्ष
matter
हेलाଣି।
because lordship was granted interim bail And Lordship, I'm due time surrender, my lord. That is the
Surrender.
yes, my lord. That is the certificate. Enter. Lordship, my time.
The petitioner was.
Page 7, my lords.
Granted. And you surrender possible in time.
Page 7.
340 kg.
Yes, my lord.
Lordship.
Lordship.
Next.
Grateful, my lord.
Item number 9. May I please, Lord? Lord, 775 kg, my lord. Costed since 4 June 2020, my lord.
2020.
Yes, my lord. 3 years.
Koodi ka loka?
Your lordship kindly see the last
Koodi ka
order.
loka ye? Odisha?
No, Andhra, my lord. HIV patient.
Alga state में HIV patient मरू ना था मरण थी नहीं मरू ना थी बहुत medicine वाला
Your lordship kindly see the last order, 5th September order. Order number 2, my lord.
Order number
2. Call for the report, my lord. Your lordship has called for the report from the registry, my lord. On
yes,
3 points, my lord.
record for that.
Yes, ma'am. As per my instruction, till that no witnesses has been,
देखा जाओ नहीं
as per my instruction, my lord, till that no witnesses has been examined.
रो में तमाम instruction सुनी ना decision instruction देखी तमाम instruction भूल वाली भी पड़ी that's why I'm listening. Seven number of witnesses have cited as charge sheet witness. Out of them, one witness has been examined, and this. गोटे मास भीतर सार देबे कहउछन जज वेट करछन गोटे मास
3 years
ना सारला देखे
HIV patient, my
अरे
lord.
ऐसा में तो किछ हेइनी ना
अब last occasion, my lord has said that.
HIV patient कोन असुविधा हेछि
This is the health report of the.
HIV patient हे गेला किछ असुविधा नहीं
Last occasion, my lord कहथिले एटा.
अरे हॉस्पिटल जदी बेसी कोन हला हॉस्पिटल लेबे बेसी
Last occasion कहथिले दे दे.
दे कहथिली मु किछ जानिनी मु जा कहते से नेक्स्ट मंथ भूली जाम I have a right to forget it. I can forget. किसी तो असुविधा नहीं मेडिसिन खाउछन तो ठीक ठाक अछन असुविधा
I am citing a judgment, my lord.
जजमेंट कोन करबी मो फैक्ट्स जजमेंट ए बेल दाबे की जजमेंट बेल जुरिस्प्रूडेंस पृथ्वी रे नाही कोठी आ तम भालो जजमेंट देखाबे पृथ्वी रे बेल जुरिस्प्रूडेंस कोठी नाही बेल इज ऑलवेज डिस्क्रिशनरी जुरिस्प्रूडेंस
Yes, my lord.
आ सेठी तम जजमेंट देखाने मते
HIV patient, my lord.
HIV patient कोन हला
3.5 years in custody, my lord.
health condition is stable and he is taking regular medicine at the behest of the jail
Let it come after vacation, my lord.
officials and the petitioner and the report of the district judge suggests that the trial is in progress and it is likely to be over within very short
My lord, it
time.
was.
Hence the petitioner's case बेसी 7 लोक मात्र जणे हेजन 6टा से मास भीतर सार देबो
Trial was twice it is targeted, my lord. It is the 4th application of the.
टारगेट तो भूल टारगेट जे करछि भूल मु भी भूल करछि टारगेट करिया कथा नहीं टारगेट कथा कहबेनी मो कोट हला नो टारगेट
After vacation.
नो सॉरी आ टारगेट नहीं एठी में
टारगेट न था after vacation.
नहीं मो किछि
After vacation
आथर फाइल कलो असुविधा अछि
ना 4 थर फाइल कले
पेंडिंग पर अछि
4 थर फाइल कले, my lord.
और 5 थर करन कोन टाइगला
4 थर फाइल
मना
कले
अछि
4 year approximately 4 year in custody, my lord. HIV patient, my lord.
तो कोन टाइगला तो क्राइम काय करथल कि HIV पेशेंट दे द का क्राइम काय करथल
Last occasion, my lord कहथिले भी एटा
HIV पेशेंट कहला बनी मास रे सरी जेवल कहछि न सरला आइबे हला
Liberty may be granted to
କାହିଁକି
master କହୁଛନ୍ତି ସେ
ଲିବର୍ଟି ଗ୍ରାଣ୍ଟ କରିବି
ମାସ
Liberty
ଭିତରେ
ମାଗଣା
ସାରିବା
ପଡିଛି।
ମାସ ଭିତରେ ସାରିବା ପାଇଁ ଟାର୍ଗେଟ କରିଛନ୍ତି।
ଆରେ ଲେଖିଛି ପରେ ସେ କଣ ଟାର୍ଗେଟ କରିବି ସେ କହିଛି ଟାର୍ଗେଟ ପରେ ମୁଁ କରୁନି ଆଜିକାଲି
ଆଜ୍ଞା କରିଥିଲେ ଦିଥର କିନ୍ତୁ ଏଇଟା
କରିଥିଲା ଭୁଲ କରିଥିଲି ପରେ କହୁଛି I can't make mistake.
ଆଜ୍ଞା
You can only make mistake.
ଚାରିଥର ଆଜ୍ଞା ଆସିଲାଣି।
I have also right to make mistake.
ମାନେ ଚାରିଥର ଆଜ୍ଞା ଆସିଲାଣି that is my
ଆସୁ 5 ଥର ଆସୁ ଓକେ ଯାଅ
ମାନେ some liberty may be granted
ଲିବର୍ଟି
ମାନେ
କଣ ଦରକାର
କିଛିଟା ଆଜ୍ଞା ଦିଅନ୍ତୁ ଯାହା ଫଳରେ
ଲିବର୍ଟି
I can save from this court।
ଦଉଛି
ଆଜ୍ଞା
ଲିବର୍ଟି ଦେବି ତମକୁ
ଆଜ୍ଞା ହଉଛି ସମସ୍ତଙ୍କ ସେଇଥିପାଇଁ
ଏମିତି କ୍ୱେଶ୍ଚନ ପଚାରେ କିଛିଟା ଦେଇ ଦିଅନ୍ତୁ କଣ କିଛିଟା ଦେଇ ଦିଅନ୍ତୁ ରାଇଟ୍ you should assert your right why is he asking for like a beggar
my lord 3 years
କିଛିଟା ଦେଇ ଦିଅନ୍ତୁ କିଛିଟା ଦେଇ ଦିଅନ୍ତୁ
ଆଜ୍ଞା ଚାରିଥର he has approached before this court।
4 ଥର 5 ଥର କରୁ କ୍ରାଇମ କରିବ ତ କରିବ ଆଉ କଣ ତମ ଆଗରୁ ଦେଲି ପରା କାଇଁ ତାର ବହୁତ ଲମ୍ବା ଲିଷ୍ଟ ଅଛି ଆଉ ଅଧିକ ସମୟ ଲାଗିବ ତାକୁ ଦେଲି ଆପଣ କାଇଁ ଦେଲିନି ମାସେ ଭିତରେ ସରିଯିବ କହୁଛି ନହେଲେ ଦେଖିବା ପ୍ଲସ୍ ଆପଣ ଆନ୍ଧ୍ରର ସେ ଓଡିଶା ଲୋକ ହେଇଥିଲେ ଦେଇ ଦେଇଥାନ୍ତି ପଟକିନା ଆନ୍ଧ୍ର ପଳେଇଗଲା କି ଆଉ ଆପଣଙ୍କୁ ଧରା ଛୁଆଁ ଦେବେନି ତେଲୁଗୁ ଭାଷାରେ ଆମ ପୋଲିସ ଯାଇକି ଖୋଜିଲା ବେଳେ ମୁସ୍କିଲ
any condition may be
କିଛି नो कंडीशन सॉरी डिसमिस्ड ओके नेक्स्ट बाकी